ಬಂದಿರೋವನ್ನ ಕಳ್ಸಿರ್ತೀವಿ.
ಚೇತನ್ 1165. 1165. Okay. ಸರಿ ಸರ್.
Consider it, sir. We'll consider it.
Page number 3, seal number 36 to 43.
Four zero. ಇದ್ರದ್ದು 40, 80, 90 ಇದೆ. ನೀವು ಯಾವ್ದು ಹೇಳ್ತಾ ಇದ್ರಿ? Forty two ಅದು. Memo for withdrawal of the petition. Memo is placed on record. Clear the memo. The petition is dismissed as withdrawn. ನಮ್ಮಲ್ಲಿ ಇಲ್ಲಿ ದೇವಿಂದ ಯಾವ್ದು? 40 times.
My lord, serial number 46, my lords, appear for the petitioners, requesting for a week's time, my lords.
Memo or withdrawal of the petition. Memo is placed on record. Petition. The memo petition is dismissed as withdrawn.
Serial number.
You are representing Pratik. 2 weeks as per request. 2 weeks.
Serial number 46, my lords.
1 week 44.
Lord, serial number 46, requesting for a week's time, my lords.
2 weeks.
Petition number 5, serial number 57 to 60.
Serial number 56, my lord.
ಕೊಡಕ್ಕಾಗಲ್ಲ PF ಗೆ ಕೊಡಿ, PF ಅದು ಕೊಡಿ. ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ ಮೊದಲ. ಈ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿದ್ರೆ ನೀವು ಟೈಮ್ ಕೇಳಬೇಕಾಗಿಲ್ಲ, ನಾವು ನೋಟಿಸ್ ಕೊಡ್ತೀವಿ. You are supposed to furnish PF copies for issuing notice to other side. Then I'll issue notice. That's all.
My lord, serial number 56, my lord.
62 weeks.
My lord, 56, my lord.
Hey, Swami, 1 ನಿಮಿಷ ತಡ್ಕೊಳ್ಳಕ್ಕಾಗಲ್ವಾ? ಏನ್ 63 ಏನಿದು? ಸರಿ. ಅಲ್ಲ ಏನೋ ಆಫೀಸ್ ನೋಟ್ ಹಾಕಿದ್ದಾರೆ. ಸಕ್ಸೆಸಿವ್ ಹೆಂಗಾಗುತ್ತೆ ರೀ? 438 to 439 ಸಕ್ಸೆಸಿವ್ ಅಲ್ಲ. And withdrawal author, that is not a pass any orders on merits. 63 next week.
My lord, 56, my lord.
Time ಕೇಳ್ತಾ ಇದ್ರಿ? 65, 67, 2 weeks.
56, my lord. Kindly wait 1 week, my lord. 56, my lord.
56 ಹೋಯ್ತು ಸರ್, ಈಗ ಬರ್ತಿದ್ದೀರಿ ನೀವು ಪೇಜ್ ದಾಟಿದ ಮೇಲೆ.
I submit ಮಾಡಲ್ಲ, my lord.
56, 56, 2 weeks.
Oblige, my lord.
ಎಲ್ಲ ಯಾವಾಗ ಬೇಕಾದಾಗ ಬಂದು ಮೆಮೊ ತಗೊಳ್ಳಲ್ಲ ನಾವು. ನೋ ವೇ ಕನ್ಸರ್ನ್. ನಾಳೆ ಕೊಡಿ ಬೆಳಿಗ್ಗೆ.
Page number 68.
Page number
68. Yes, yes, sir. Okay.
the office has raised objection regarding the specific number of ACMM report disclosed, report with serial number 38 disclosed that initially matter was pending before seventh additional, seventh ACMM, and now it is transferred to 39th ACMM. Hence, office objection is overruled. HCGP is directed to take notice for respondent state, along for objections of 2 weeks. Yes.
The petitioner is not valid. It is A1 man. Always. Petition is based by the A1 man. For order. And A1 is
ಹೇಳಿದ್ರಿ ನೋಡ್ತಾ ಇದೀನಿ. The office has raised objection that name of the petitioner does not tally. But the petition is filed by Mahendra alias Manikanta, who is shown to be accused number 1 in the charge sheet. The order in special POCSO case also discussed that bail petition filed by accused number 1 stands was dismissed. Hence, office objections are overruled. Learned HCGP is directed to take notice for R1, issue notice to R2, please the matter. 512. ಮಾಡಬೇಕು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಆಯ್ತು. ಪೋಕ್ಸೋ ಇದ್ದಾಗ ಯು ಆರ್ ಬೌಂಡ್ ಟು ಪಿಟಿಷನರ್ ಇದೆ. How you can make a minor party? How can you make a minor party unless he is represented by a minor guardian? 13 years child, you want her to make a party?
19.
Now, Prashna Uttara Kodi, sir. How can you make a minor aged about 13 years as a respondent number 2? Minor guardian ಮಾಡಬೇಕು. 2 weeks time for office compliance of office.
Serial number 2, my lord. Abuse objection, my lord. Serial 2, office raised wrongly objection, my lord. Serial number, may I submit? Serial number 2, my lord. The office wrongly raised the objection, my lord.
What is the objection?
Office raised the objection that the original complaint or guardian not made as a party. I have made the represented
You have
by
made the
a
party but without providing address.
my lord.
You are supposed to furnish the address of the minor guardian.
I have furnished the address as well as father.
You are
is
not
made as a
furnished.
party.
You have simply stated that Rakshita as a party represented by Father Rajsekhar V. No further details were given. Complied.
Page number 2, my lord.
Now page number 2 ನೋಡೇ ಹೇಳಿದ್ದೀನಿ ನಾನು.
Serial number 7. Office objection email ID ಇದೆ.
Minimal ಇರ್ಲಿ ಏನಿಲ್ಲ. That is not a criteria. Complied. Comply ಮಾಡಿ. No comply ಮಾಡೋರಿಗೆ notice target. Conditional comply ಇಲ್ಲ. Comply ಆದ್ಮೇಲೆ notice. ನೀವು ಬೇಕಾದಷ್ಟು ತಗೊಳ್ಳಿ. ನಿಮಗೆ ಟೈಮ್ ಕೊಟ್ಟಿರ್ತದ 438 ಅದ 2 weeks time you will get you comply. 439 ಇದ್ದಲ್ಲಿ 1 week ಸಿಗುತ್ತೆ ಕಂಪ್ಲೈ ಮಾಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ನಿಮಗೂ ಅಷ್ಟೇ 2 weeks ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೀವಿ. cancellation of bail, urgency ಏನಿಲ್ಲ. Cancellation of bail 439 + 2 ಕೆಳಗೆ ಬಂದಿದ್ದೀರಿ. ಕಂಪ್ಲೈ ಮಾಡಿ. ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅದಕ್ಕೆ. ನಿಮಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಲ್ರಿ. ನೀವು ಯಾವಾಗಾದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಡಿನೈಡ್ ಯುವರ್ ರೈಟ್. ಕೊಟ್ಟಿದ್ದೀನಿ, ಕಂಪ್ಲೈ ಮಾಡ್ಕೊಡ್ರಿ. ಸರ್ ಮಾಡಿ.
Given to 35 minutes of this service time.
21 to 23, 25 to 30. ಇದಕ್ಕೆ 24 ತೆಗೆರಿ ನೋಡಿ. ಲೋಕಾಯುಕ್ತಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. Or issue notice to the respondent, Lokayukta. You are served to a penal advocate, sir. ಅವ್ರನ್ನ ಕೊಡ್ತಾರಂತ ಗ್ಯಾರಂಟಿ ಇರಲ್ಲ ಅಲ್ವಾ? 612. ಸಿಕ್ಕಿದಾಗ ಎಲ್ಲಾದ್ರೂ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ನೀವು. And in case R2 is there, notice ಕೊಡಿ.
Order 36 narration.
No, it is a 458 petition. Petitioner is the number 3. In this case, my lord, the property site was belonged to Chikkanamaya. He had 3 sons. After the demise of Chikkanamaya, the sons transferred the property to number 1, number 2. Then from him I purchased the property. Subsequently, upon I purchased the property, I have paid a suit for declaration and injunction.
ವೆರಿಫಿಕೇಶನ್ ನೋಡಲ್ಲ ನಾನು, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ ನೋಡ್ತೀನಿ ನಾನು.
What happened was, the contention of the complaint, in the complaint, which dated 2025 number 11 of the complaint. The complaint also got written complaint. The file number 11, file number 12, file number 3. File number 12, file number 3. I state that Srimati Amuda, who was well aware of the fact, 2011, has sold item 31 to Kartik. So, the case of it is that a suit for injunction was filed. In that injunction suit, I was made of the parties, and my case was not pursued. I did not pursue this case. That case was dismissed for non-prosecution for injunction. Next, prior to one paragraph, when you turn to previous page. In this case, it says that the said Kartik attempted to come on the property. I resisted his move on 6/9/2011. He failed 65/42/2011. Seeking judgment and decree of injunction.
ಇಲ್ಲ, ಈ ಪಿಕ್ ಅಂಡ್ ಚೂಸ್ ಓದ್ತಾ ಇದ್ರಿ, ಕೇಸಿದ ತಲೆ ಬುಡನ ಅರ್ಥ ಆಗಲ್ಲ. You are simply picking one sentence in the complaint, reading and again going back. Yeah, ಹೆಂಗೆ ಅರ್ಥ ಆಗ್ಬೇಕು ನಿಮ್ ಕೇಸ್.
The case of the complaint is there. I will go through the file number 12, number 2. I state that suppressing the order, this order, Gundappa, though he had no ownership over the property in question, though he said that property was not available for sale, he executed sale date on 9/7/2009 in favor of Amuda. It is relevant to mention that here that the sale deed, he was wrongly disturbed the measurement as inserted. but site number 31 measures 1,800 square feet. He clandestinely matched the boundaries with the may say it. In fact, this is a fraudulent transaction to outreach the order of honorable court to knock up the property. The said fact was the site number 39 was clearly sold to me. The intention was to go to unlawful gain. No, my lord, next paragraph. I said that after executing the sale deed 10/11/2009, one Muthu Matsudan also filed suit 27/2/24 of 2009 against Gundappa seeking injunction. That injunction in the case of respect the said suit also court was pleased to pass identity injunction against him. It was declared that is injunction suit. No, my lord, he said that he filed a suit for injunction. File number.
ಸರ್ ನಿಮ್ ಕೇಸ್ ಏನದ ನನಗೆ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. See, you first enlighten me. What is your case?
We kept the complainant purchase the site from.
What is the site number? There are a number of sites. What is the site number he has purchased?
He purchased site number 31.
31. What are the original boundaries of site number 31?
The site number 31, according to him, he purchased from one Chikramaya in 1991. He filed suit for injunction. Suit for injunction, and then that suit was declared. He claims that it was his title suit. Suit for injunction.
ನಾನು ಕೇಳ್ತಾ ಇರೋದು, what were the boundaries of site number 31 when the complainant has purchased it in 1991? Simple ಪ್ರಶ್ನೆ.
The complainant was.
What are the boundaries of the site number 30? How can be a single site having a different boundaries?
Here is the case where.
ನಾನು ಒಂದೇ ಪ್ರಶ್ನೆ, ನಿಮ್ ಕೇಸ್ ಇರ್ಲಿ, ನನ್ ಪ್ರಶ್ನೆ ಒಂದೇ ಸೈಟು ಬೇರೆ ಬೇರೆ ಬೌಂಡ್ರಿ ಮುಖಾಂತರ ಹೇಗ್ ಮಾರಾಟ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ?
ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ 1951 my father purchased the property. My father dated 2002. My Gundappa sold to Aki number 2. Aki number 2 sold to Aki number 3. Just married property.
ಏನ್ರ ಆಗ್ಲಿ, ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಒಂದು ಸೈಟ್ಗೆ ಬೇರೆ ಬೇರೆ ಬೌಂಡ್ರೀಸ್ ಹೇಗ್ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ?
ಸಾಧ್ಯ ಇಲ್ಲ ಸರ್. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ ಎರಡು ಕೋರ್ಟ್ ಕೇಸ್ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಬೌಂಡ್ರಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲ ಇದು. ಓನ್ಲಿ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಕೇಸ್ ಆಫ್ ಎ ಬೌಂಡ್ರಿ ಡಿಸ್ಪ್ಯೂಟ್. ಬೌಂಡ್ರಿ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗುತ್ತೆ. ನನ್ ಬೌಂಡ್ರಿ ಇಲ್ಲಿ ಬಂದಿದೆ, ನನ್ ಬೌಂಡ್ರಿ ಇಲ್ಲಿದೆ. ದಟ್ ಈಸ್ ಎ ಡಿಫರೆಂಟ್. ಹಿಯರ್ mentioning the entire boundaries itself is
my property is 2000 square feet. That property
not concerned. My question is, site number 31 is the disputed property. What are the original boundaries of site number 31?
That is not failed in court. A civil suit, a civil dispute, as if a property purchased by me in 2011, I filed a suit for the declaration injunction. That in that suit,
Charge sheet is filed.
no, my lord. In this case, my lord,
438
Hello, 433 complaint was filed in March.
there is injunction order against the original complainant to make it status quo. That suit I withdraw it. Because the suit.
When you withdraw the status quo also goes with it.
That's in the 2012. I withdraw it in 2012. Because his complaint filed in 2013. I withdraw the suit. I sold it.
Not able to understand your case itself.
My lord,
You're making so much confusion.
the son of Chikramaya.
ನಾನು ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳಿದೀನಿ. ಸೈಟ್ ನಂಬರ್ 31 ಅದು ಬೌಂಡ್ರಿ ಹೇಳಿಬಿಡಿ ಸಾಕು. ನನಗೆ ಇಷ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅದನ್ನ ಒಂದ್ ಬಿಟ್ಟು ಎಲ್ಲಾ ಕತೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು.
Site number 1 boundary is.
I am not site number 1. I am asking you regarding the disputed site number 31.
Boundary same. Boundary same ಇದೆ. extent ಮಾತ್ರ ಅದೇ ಬಗ್ಗೆ ಬಂದಿದೆ.
Boundary same ಇದ್ರೆ there cannot be two purchases.
ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ
There cannot be two purchases of a same site. Boundary, the extent may vary and law is settled that if there is a dispute between the extent, the boundaries will prevail.
Submission, my lord. After the death of father, sons have sold the property to action number 1. Number 2.
That is everything is okay, sir. ನಾನು ಕೇಳ್ತಾ ಇರೋದನ್ನು ಹೇಳ್ತಾ ಇಲ್ಲ ನೀವು. ಸಡನ್ ನಿಮ್ದು 1800 ಬೌಂಡ್ರಿ ಇದ್ದಿದ್ದು 2000 ಹೆಂಗ್ ಇನ್ಕ್ರೀಸ್ ಆಗುತ್ತೆ?
Some property, what was I purchased, my father purchased, he has sold it.
ನಿಮ್ದು ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲಿದೆ? ಒರಿಜಿನಲ್ ಸೇಲ್ ಡೀಡ್.
What was sold?
Where is your original ಸೇಲ್
I sold
ಡೀಡ್?
it to
Original ಸೇಲ್ ಡೀಡ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅವೈಲೇಬಲ್ ಇದ್ದೇ ಇರುತ್ತೆ. Get your original ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ. New purchase ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಬಂತಂದ್ರೆ everything.
my father purchased it.
Father purchase ಮಾಡಿದಾನಂತಂದ್ರೆ ಕಾಪಿ ಇರಲ್ಲೇನ್ರಿ?
What was it?
That is the base for your title. Simple case. Your title is originated from the sale deed executed in favor of your father. Correct? That will.
This is civil case has to go for trial, my lord.
Civil case of secondary, sir. Under the guise of civil case, if a person cheats somebody,
Is that a question of cheat, my lord? On commission, my lord.
sir, you are not prepared to argue the matter, and you are not prepared to produce the document, and you want an anticipatory
My
bail.
lord, on commission.
And my simple question now, I'll become curt. Produce the original sale deed executed in favor of your father. That's all.
My lord, on commission, my lord. The trial court is passing the order.
See, I'm not sitting in an appellate court of a order on the trial court. Now you are using, trial court has rejected your bail petition. You are seeking a concurrent in
They have finished the certificate of the.
ನಾನು ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ. I don't want certified copy of the judgment. I simply requesting you to produce the original source of your title in respect of purchase by your father. A sell deed produce ಮಾಡಿ, matter will automatically end.
My lord,
Produce ಮಾಡ್ತೀರಾ ಇಲ್ಲ?
ಏನಾಗುತ್ತೆ?
As per request.
I want to CD.
ಎಲ್ಲ ನಿಮ್ಮ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ ಟೈಮ್ ಹೋಗಿದೆ. ಸಿಡಿ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ. CCTV footages. Then subsequently the petitioner has started, ಇವತ್ತು ಡೇಟ್ ತಗೊಂಡಿದ್ದೀರಾ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಅಂತ.
To driving the car. ಬೇಕಾದ್ರೆ ನೀವು ನೋಡ್ಕೊಳ್ಳಿ.
Yes. The CCTV footage is disclosed that in the particular vehicle car, he dropped, that car belongs to him. A1 was dropped there. The car taken a U-turn. The again A1 comes, boards the car and the car moves. You now you will have to say the car belongs to you, whom you have handed over. Charge sheet ಇದೆ ಆಗಿದೆ. Charge sheet ಆಗಿದ್ರೆ you are bound to furnish copy ಅಲ್ಲ. Charge sheet ಆಗಿದ್ರೆ ಕೊಡ್ಲಿಕ್ಕೆ ಏನು ತೊಂದರೆ ಇದೆ ರೀ? Charge sheet ಆಗಿರಲಿಲ್ಲ ಅಂದ್ರೆ part of the investigation I can understand. Now since final report is submitted, he is entitled. ನಾವು ಇಲ್ಲೊಂದು ಕಾಪಿ ಕೊಡಿ ಏನ್ ಆಗ್ಬೇಕಾಗಿದೆ ಅವ್ರ ಕಡೆಯಿಂದ ಇದ್ರೆ ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಇಸ್ಕೊಂಡು ಹಾಕಿ ಲೋಡ್ ಮಾಡಿ ಕೊಡಿ ಅವ್ರಿಗೆ he can verify it because the charge sheet is already filed, so there is no question of further investigation in Procedural. So he is entitled to go through the entire material which is relied by the prosecution so as to get his defense prepared. That right cannot be denied. Source of copy ಕೊಡಿ ಅವ್ರಿಗೆ, let him study it. ಏನಾಗ್ಬೇಕಾಗಿತ್ತು ನಿಮಗೆ? CD ಒಳಗಡೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರದ್ದು ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಇಟ್ಕೊಡಿ, ಅವ್ರ ಕಡೆ ಪೆನ್ ಡ್ರೈವ್ ಇರ್ತಾವ ಸಾಕಷ್ಟು, ಅದ್ರಾಗ ನಿಮ್ದೇ ಇದೆ ಪೆನ್ ಡ್ರೈವ್ ಕಾಪಿ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಅಲ್ಲ ಈಗ ವಕೀಲ ಕಡೆ ಪೆನ್ ಡ್ರೈವ್ ಇರೋದು ಕಾಮನ್ ಸರ್, ಬಿಕಾಸ್ ಎಲ್ಲ ಇದನ್ನ ತಗೊಳ್ತೀರಿ ನೀವು ಸೈಟೇಷನ್ಸ್, ದಟ್ ವಿಲ್ ಬಿ ಅವೈಲೇಬಲ್. ಈ CD ಇಸ್ ಔಟ್ಡೇಟೆಡ್ ಈಗ. ಅದಕ್ಕೆ ನಾನು ಪೆನ್ ಡ್ರೈವ್ ಅಂತ ನಿಮ್ ಕಡೆ ಕಾಮನ್ ಇದ್ದೇ ಇರುತ್ತೆ. ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ನಾಳೆ ಕೊಡ್ತಾರಂತೆ. ಯಾವಾಗ ಇಡ್ಲಿ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ 30th. ಅಲ್ಲ, ನಾವು ಪ್ರೆಸೆನ್ಸಿ ಆಫ್ IO ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್. ವಿ ಆರ್ ಕನ್ಸರ್ನ್ ಟು ಪ್ಲೇ ದಟ್ ಇದು ಅಷ್ಟೇ, ಅದಕ್ಕಷ್ಟೇ ಸೀಮಿತ. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ಅಂಡ್ ಯು ಶುಡ್ ಗೆಟ್ ಯುವರ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ನೀವು ಸ್ವಲ್ಪ ಟ್ರೈನ್ ಮಾಡ್ಕೋಬೇಕು ಹೌ ಟು ಪ್ಲೇ ಇಟ್. ಎವ್ರಿ ಟೈಮ್ ಯು ಕ್ಯಾನಾಟ್ ಕಾಲ್ ದಿ IO ಟು ಪ್ಲೇ ಇಟ್. ಸಿಂಪಲ್ ಥಿಂಗ್ ರೀ, ಅವ್ ಏನ್ ಈಗ ಇಷ್ಟು ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಇಲ್ಲ, ಅದು ಸಿಂಪಲ್ ಈಸಿ ಆಗಿ ಎನಿಬಡಿ ಕ್ಯಾನ್ ಪ್ಲೇ ಇಟ್. ನಾವ್ ಇದ್ದಾಗ ರೆಕಮೆಂಡ್ ಮಾಡಿದೀವಲ್ರಿ ನಿಮ್ ಸಲುವಾಗಿಯೂ, ಎಲ್ಲಾರ್ಗೂ ನಿಮ್ಗೂ ಒಂದ್ ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ. ನೀವು ಪರ್ಸುವೇಷನ್ ಮಾಡ್ಬೇಕು, ಎಲ್ಲ ಹೈಕೋರ್ಟ್ನವ್ರ ಮಾಡ್ಬೇಕಂತ ಎಕ್ಸ್ಪೆಕ್ಟೇಷನ್ ಮಾಡೋದು ತಪ್ಪಲ್ವಾ? ನಾವ್ ಮೂವ್ ಮಾಡೋದಷ್ಟು ಮಾಡ್ತೀವಿ, ಅಲ್ಲಿ ಫಾಲೋ ಅಪ್ ಮಾಡೋದ ನೀವೇ, ಅಲ್ಲಿ ಒಪಿನಿಯನ್ ಕೊಡೋರು ನೀವೇ. ಯಾಕಂದ್ರೆ ಎಸ್ಪೆಷಲಿ ಅಟ್ ದಟ್ ಟೈಮ್ COVID was prevailing. Therefore, there was a direction that each government advocate should be provided with laptop. ನೀವು ಬಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದು ಗೊತ್ತಿದೆ, ನಮಗ್ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಒಳಗ ಅನನುಕೂಲ ಆಗತ್ತೆ ರೀ, ನಮ್ ಕಡೆ ಒಂದೇ ಲ್ಯಾಪ್ಟಾಪ್ ಇರುತ್ತೆ, ಏನೇನೋ ಹೇಳಿದ್ರಿ ನೀವು. In view of that, there was a specific direction. ಆ ಡೈರೆಕ್ಷನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು ನಾವ್ ಹೇಳಕ್ ಆಗಲ್ಲ, ಅದು ನಿಮಗ್ ಬಿಟ್ಟಿತ್ತು. ನೋಡಿ 30th ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Father was living along with his servant named Vijaya. On that fateful day, night, he had gone out on a tour, and his father was alone. Closing the shop, the father and his servant had returned home. But on the next day, there was no response to the father. Therefore, he had asked. Police case was already taken. Saying that valuable was taken. Blame was on the was taken. So the blame was on the servant Vijayaram. Next to the case was the manner in which it was clear that about 11:30 when we had closed the house, when he was going back, three photo was on the face, his hand were tied on back, and he was taking bathroom. The further the procedure that it was not the intention of killing the person, it was putting into block and rob the jewels. That was the kind of intention of killing or not, and killing was the death of the death. So that is that. He was a 74-year-old man. So when he was tied on the back and went to his bathroom, he had died. The role of the abatement is that after taking the treatment and from negative, he is not a part or he adopted after time as one of the he was not directly involved. Police now is named as a legal partner, moving the block of the this is in the and you are able to engage in the very of this report any condition.
Charge sheet is submitted. You not produce the copy of the charge sheet. I think day before yesterday it was urgent for that purpose only. Matter was posted the day before yesterday, Alba. Charge sheet. Is it along with memo? No mercies. ಈ ವಿಷಯದಾಗ no compromise. ಈ ಮಧ್ಯದಿಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ? ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೋಡು. Go through it.
Next. Should be.
Have you filed power? Legal service authorities file power ಬರಲ್ವಾ? You'll file first power, sir. Either the matter is interested ಅನ್ನೋದು ಏನಿದೆ? File power. Password ಮಾಡಿ power.
Legend 41 is product.
Legal counsel for petitioner called out absent. Into matter after 2 weeks. ಅವ್ರು ಅಪೇರ್ ಆಗ್ಬೇಕಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ನಾವು. ಹೆಚ್ಚಿದ್ದೀವಿ. It is noticed that HCGP is directed to take notice, but the respondent is represented by NCB. Hence, issue notice to respondent Internet on 6.
Srinivasan, second part. What movie?
Objection to other side.
What movie?
44 ಡೇಟ್ ಆಗಿದೆ ಅಲ್ಲ ಅವ್ರು ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. ಯು ಆರ್ ಫಾರ್ ಅದೇ ಯು ಆರ್ ಪರ್ಮಿಟೆಡ್ ಓನ್ಲಿ ಟು ಅಸಿಸ್ಟ್. So you are penal advocate. You are petition counsel. ನೀವು ಇಲ್ಲಿ ನಿಂತು ಪೆಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅಂದ್ರೆ ಸಿಕ್ಕಾಪಟ್ಟೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ಆಟೋಮೇ ಅದು 44 ಅವರು ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಬೆಳಿಗ್ಗೆ. 1 ವೀಕ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಇದು 47 ಅಲ್ವಾ? ಎಸ್ ಸರ್.
On 31/10/2020, that was good. We filed a missing complaint against the fund. The day after blood, it is alleged that on 1/11/2020, the incidents of committing a murder by the accused has been an allegation by the complainant. And on the basis of the complainant's blood, on 31/12/2021, after the lapse of 1 year, the complainant has filed a complaint. Complainant is the father-in-law of the accused, and on the basis of the complaint, I was filed the charge, filed the FIR, and there was investigation was done. Thereafter, on the completion of this reward, the accused admitted that he has done it only on the confession.
No argue, no, don't argue this because the confession statement before IO is inadmissible.
Thereafter,
What is the evidence now collected becomes only relevant. Let it be. What is the investigation is concluded? What is the evidence collected? ಇಷ್ಟೇ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ನಾನು ವಿರುದ್ಧ.
we have entered to the place where the dead body was stated to have been thrown by the accused. And it is already created facts actually, by the reward. Created facts. He has been compelled to do all these things and do all these things. Because he has been really dead, he has been captured by the IO. And that is why this the IO have insisted that his mother also will be taken into custody.
ಆಯ್ತು that is not there.
That fact, yes,
What is the materials recovered ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
there is no recovery at all.
Even dead body.
Yes. No.
So entire case is circumstantial.
Has happened, the incident has happened about 1 year back in the record. And the FIR was filed up to 1 year of the incident.
You have lodged a missing complaint.
Yes. Only on the day of the missing complaint, the next day it is alleged that the incident has happened. Further on that day, my lord, the accused was on duty in office.
If your wife is found missing, as per your complaint, how did her Mangala Sutra was found in your custody? How you came in possession of Mangala Sutra of your wife Mangalya? Huh? It is not found to me means
Investigation only we have.
they specifically there is allegation whether it is otherwise we will consider it independently. There is a specific allegation that a Mangalya chain was recovered from your house. You cannot keep a mangalya. It should be on the body of your wife. How it came to your house? One of the strong circumstances at this juncture. It is. See, that is a compulsion, one thing. Planting a Mangal Sutra is different. How the Mangalya came in possession of accused, you are not able to answer. Yes, what you have to say? Charge sheet is filed, that is a different aspect, sir. Recovery now, Mangalya, who should be on the body of the deceased? That Mangalya was in your possession. You cannot see, it is not your case that she kept. If you lodged a complaint asserting that she kept the Mangala chain in the house and then she found missing, things would have been different. The simple case is she is found missing on 31/12/2020. And she was alleged to have been murdered on 1/11/20. Your missing complaint is after 2 months. Your missing complaint is after 2 months. 1 month. Your missing complaint is on 31/10. Yes, even ಹೇಳ್ತೀರಿ.
Got married to the accused 3 years back.
No children.
Thereafter, Malak is instructed. The motive for committing the murder of the deceased. But on the date of the incident, he took the decision and asserted, and when he confessed the murder of the deceased and took the dead body in the car and drove it to the river. Plus, efforts are being made to cut the dead body and find out efforts are not wasted. Then after coming after throwing the dead body into the river, he took the car is particularly clear and the routing of the PS number 383. Number 43 melons, PS number 3, number 1. Dumas word Mangala Temu, Single Silva, one the card is single Silva, next one over. Mars the Karnataka that belongs to the Mars are melons at 846. 45 minutes last. That's the bottom second line minutes.
What is the age of the child? 5 years. When your wife was missing, where the child was?
During the time of missing, he was with the mother and the Bonsai was also head of the Robbery police station. To Bonsai, he went out. The next day it is alleged that he received a sentence.
Where is your complaint? Copy of your missing complaint? But the fact remains that you have lodged a missing complaint on 31/10/2020. Your missing complaint is not only regarding your wife, but it is in respect of the child also. Isn't it? Both child and your wife were missing. Then they were secured to the police station, and after conciliation, they were sent along with you. So missing complaint closed there itself. Then they were in your custody. So from 1/11, they are in your custody. When she parted, so missing complaint doesn't arise now. So you are supposed to explain. Burden is on you as per 106 of the Evidence Act. When she parted away from your company, leaving yourself and your child, see, that is a different aspect, because the complainant has simply set the law in motion. Even after your wife was again found missing from 1/11, she was not found in your custody. She was untraced. After 1/11/20, did you file any complaint? Why? When you are initially 31st, you filed a complaint that your wife and daughter is missing. Very next day, police secured them, advised, and they were sent with you. Then again, your wife found missing. A husband did not lodge a complaint in respect of missing wife for 1 year. I'm not asking, I'm simply asking you. Do you mean to say that from 1/11/2020, she was residing with you?
Yeah, it has to be.
See, I'm asking you, it has to be different. I'm asking you, you are the best person. Till which date she was with you and when she found missing? No, that is, you are the person responsible. She was sent with you and you did not lodge any complaint regarding missing of your wife. Then where is she has gone? You should be knowing, Allah. Then how she found, she, then presumption is that she should be along with accused. Okay, fine, that okay. Then when she lost, when she found missing, it is not known to her. The complainant has simply filed a complaint that his daughter is missing. So burden is on you now to explain when your wife has gone missing. And if she was gone missing, why you have not taken steps to report to the nearest police station?
In that period of 1 year,
You are the best person. Your wife is not seen for 1 year and you are least interested. You are not even ventured to file a simple complaint. Earlier day you filed a complaint, they secured, they sent along with you, but again she found missing, but you don't take any proper steps. What is to be presumed? The role of the complainant is only formality, set the law in motion. Nothing more, nothing can be attached, but under 106 of the Evidence Act, you are the custodian, you were residing together, you are supposed to explain when she found missing. Why you are not taken steps to trace the missing wife? Nothing is there.
matters very large. Plus, it is the matter is
This question of pre-trial is secondary, sir. Yes. Hold
the undergo for the trial. So they are several conditions are to be imposed in the return daily. Imposing the several conditions. His mother is also there with 55 years, also the we have got 3 or 2 years. Okay, there is nobody to look up for them in the life.
The petitioner has filed the petition under section 439 of CRPC for enlarging him on regular bail in Tavrekere PS crime number 383 of 21, registered for the offence punishing under section 302 and 201 of IPC. The third, the learned counsel for petitioner and learned HCGP for respondents. There is the records. The brief factual matrix leading to the case are that the deceased Deepa was the wife of the petitioner and their marriage was solemnized about 8 years earlier. It is further alleged that they had a daughter aged about 4 to 5 years by name Shobit. It is also alleged that all along the petitioner used to quarrel with his wife by suspecting her character, and in this regard, the complainant and others have advised them in November that on 31/10/20, the petitioner has given a complaint to Harohalli police station regarding missing of his wife and daughter. Later on, the police have secured Deepa, the deceased Deepa, the minor daughter, and complainant and his family members, and the petitioner was advised, and both wife Deepa and Shobita were sent along with them. It is further alleged that then the the present petitioner took his wife and minor children on his two-wheeler, asserting that he will have a separate rented house and he is going to stay in Kadshikoppa. He will shift his residence from Kadshikoppa village. However, thereafter, his whereabouts was not known to the complainant, and even in December 20, the marriage of his son Mohan was solemnized, but even during that period, the deceased as well as petitioner did not attend the marriage. Later on, the complainant got information that the petitioner was residing in Lakshmipura along with his daughter alone, and his daughter Deepa was found missing since last 1 year. Hence, suspecting the role of the present petitioner, he lodged a complaint on 31/12/21. On the basis of the complaint, crime came to be registered. The petitioner was apprehended, and at his instance, he was interrogated, and at his instance, the muzzle was drawn, wherein the alleged offense was committed, and dead body was thrown by the deceased, and the mangala chain and other ornaments of the deceased were recovered at the instance of the present petitioner. Hence, the investigating officer. However, the dead body of the deceased, which was alleged to have been thrown in Rashobhavati Nala, was not at all traced, and the complainant and the investigating officer has submitted the charge sheet subsequently. The petitioner has approached the learned session judge, and learned session judge has rejected his bail petition. Hence, petitioner is before this court. Having heard the arguments and perusing the reports, it is undisputed fact that the deceased was the wife of the present petitioner, and she was found missing for nearly 1 year. Initially, the petitioner has lodged a complaint on 31/10/20 regarding missing of his wife and a minor daughter. But however, on the very next day, the police have secured them, and in presence of the complainant, they were advised, and the present petitioner on his two-wheeler took his wife and minor daughter. Thereafter, he was not seen with the deceased, and after 1 year, it is learned that he was residing alone with his daughter. Admittedly, he has taken his wife, deceased wife, along with him, and for 1 year, she was found missing. Interestingly, the petitioner did not lodge any complaint regarding missing of his wife and simply kept mum. Apart from that, the prosecution records disclose that the mangala chain and other golden ornaments belonging to the deceased were found in his house, and they were recovered at the instance of the present petitioner. It is for the petitioner to explain under what circumstances the mangalya and other ornaments of the deceased were kept in the house instead of being found on the body of the deceased. Further, his silence in not lodging a complaint for nearly 1 year creates suspicion regarding his movement. No doubt, the dead body is not yet traced, but under section 106 of the Evidence Act, it is for the petitioner to explain the facts within his knowledge, and admittedly, he was staying with his mother, his wife, but he is not prepared to explain as to what has happened to his wife. There are strong chain of circumstances at the juncture, and considering these facts and circumstances, this is not a fit case wherein the discretion can be exercised in favor of the present petitioner, as he is not prepared to explain the facts within his knowledge. Looking to these facts and circumstances, petition being devoid of any merit does not survive for consideration, and accordingly it stands rejected. The learned counsel for petitioner absent. Reached after 2 weeks. Having roster and track order. Huh? Bail another jurisdiction. This is learned counsel for petitioner called out absent. List after 3 weeks.
In this case, my lord, I'm for the petitioner 1 and 2. I received the NOC Wakalat now. I'm going to file a NOC Wakalat. I pray for 2 weeks time, my lord.
You are not there on record, sir. There is no represent. I cannot record your presence because you are not
Yesterday-
yet filed power.
My lord, yesterday only I received the NOC Wakalat.
Not a concern, sir. Learned counsel for petitioner absent as per request of the proxy advocate just after 2 weeks.
This one was married, the petitioner. They are ladies, the acting manager. But my lord, petitioner. But he uses relationship. But with the mother, mentally irrational, he has committed my lord, dying on the railway track. This is the allegation. Before he left my lord, he recorded the voice record. Voice record and he has sent the voice record. He sent the voice record, madam. That voice record, madam, earlier, UPS has sent the voice record to the Vinay, madam. After that, madam, Vinay Kumar has sent the voice record to Bakaram. Other of the district is Maria. Sorry. Basaraj has stated about the voice record. The entire practical case, practical is relying on the voice recording. The complaint ordinance, voice recording for the there is no other reason why he committed suicide. For what reason he has recorded. Did the way to be number.
Are you sure you are called under provision of parity? But I don't want your but. The simple question, whether the ground of parity, simple case, nan ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಕ್ಕೆ ಅವಕಾಶ ಕೊಡೋಲ್ಲ ಸ್ವಾಮಿ ನೀವು. Parity ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ. What is the status of accused number 2? What is the status of accused number 1? Whether accused number 2 is related to the deceased? No. That is there were certain allegations regarding he had got. Therefore, he was granted bail because his role is not directly forthcoming. But you are the wife, you are the best person to know what are the reasons for he committing suicide. You are to explain. Where you are not, sir, abatement ಗೆ ನಾನು ಜಾಗದಾಗ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ನೀ ಹೇಗೆ ಹೇಳ್ತೀರಾ ಸರ್? ನೀವು ಗಂಡ ಹೆಂಡತಿ, ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ. ನೀವು ಗಂಡ ಹೆಂಡತಿ ನಡು ಏನ್ರೆ ಗಲಾಟೆ ಆತಂದ್ರ ಒಬ್ರು ಯಾರೋ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ರ ಗಂಡಗ ಅಥವಾ ಹೆಂಡತಿಗೆ ಗೊತ್ತಿರ್ಬೇಕು ಕಾರಣ ಏನು, ಗಂಡ ಅಥವಾ ಹೆಂಡತಿ ಎದಕ್ಕೆ ಅಪ್ಸೆಟ್ ಆಗಿದ್ದಾರೆ, ವೆದರ್ ದೇ ಆರ್ ವೆರಿ ಸೆನ್ಸಿಟಿವ್ ಅದಾರೋ, ಓವರ್ ರಿಯಾಕ್ಟಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೋ. ಪಾಸಿಬಿಲಿಟಿ ಇಸ್ ದೇರ್, ಐ ಡೋಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಟ್. Overreaction, too sensitive, too possessive, personality, in what situation they were brought up, the surrounding situation, everything will count. ಇದನ್ನ ಹೇಳ್ಬೇಕಾದವ್ರು ಯಾರು? ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನ ಗಮನಕ್ಕೆ ತರಬೇಕಾದವ್ರು ಯಾರು? ಒನ್ ಆಫ್ ದಿ one partner ಅಂತೂ ಸತ್ತು ಹೋದ ಸರ್. ನಾನ್ ಕೇಳಿ ಬರೇ ಇದೆ, then rejected sir. You are not prepared to answer, then why I should hear why rejected? ಏನ್ ಸ್ವಾಮಿ ಪ್ರಶ್ನೆ ಕೇಳಿದಕ್ಕೂ ಉತ್ತರ ಕೊಡಲ್ಲ, ಬರೀ ನಿಮ್ದೇ ಕತೆ ಹೇಳ್ಕೊತ ಕೊಡ್ತಾರೆ. ನಿಮ್ ಕತೆ ಕೇಳಕ್ ಕೂತಿದ್ವಿ ನಾವು. ಕೆಲವು ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದೀವಿ, ಆ ಪ್ರಶ್ನೆಗಳು ಉತ್ತರ ಕೊಡೋ ಸೌಜನ್ಯತೆ ಇಲ್ಲ ನಿಮಗೆ. You are supposed to clarify the doubts. ಅದನ್ನ ಬಿಟ್ಟು ಗಂಡ ಹೆಂಡತಿ ಚೆನ್ನಾಗಿದ್ರು, ಅವನ್ ಎದಕ್ ಮತ್ತೆ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡ? ಯಾಕೆ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡು? Whether he was very sensitive, whether he was possessive, whether he was suffering from any other mental disorder, or whether he was having any tension in business, job, etc. ಯಾರು ಹೇಳ್ಬೇಕು? ಯಾರು ಹೇಳ್ಬೇಕು? ಯಾರು ಹೇಳ್ಬೇಕು? ಪ್ಲೀಸ್ ಅಲ್ಲ, ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಯಾರು ಹೇಳ್ಬೇಕು? ಕೇಳಬೇಕಾದವನು ಒಬ್ನು ಸತ್ತು ಹೋದ, ಉಳಿದವ್ರು ಯಾರು ಹೇಳ್ಬೇಕು? ಅದಕ್ಕೆ ನಿಮ್ಮಲ್ಲಿ ಉತ್ತರ ಇಲ್ಲ. ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್. ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಮೊದಲು ಉತ್ತರ ಕೊಡಿ, ಆಮೇಲೆ ಅದಕ್ಕೆ ಏನಾದ್ರೂ ಎಕ್ಸ್ಪ್ಲೇನೇಷನ್ ಜೋಡಿಸಿ. ನನ್ನ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಲ್ದೆ ನೀವು ಟ್ರೈಂಗ್ ಟು ಗಿವ್ ಎಕ್ಸ್ಪ್ಲೇನೇಷನ್ ಸ್ಟ್ರೇಟ್ ಅವೇ. ನನ್ ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ, ನಾರ್ಮಲಿ ಯಾರು ಹೇಳ್ಬೇಕು ಇದನ್ನ, ಈ ಎಲ್ಲ ವಿಷಯಗಳನ್ನ? ಅವನು ಹೀಗೆ ಇದ್ದ, ಹೀಗೆ. ಸೊ ವೈಫ್ ಹಸ್ಬೆಂಡ್ ನೋ ವೇ ಕನ್ಸರ್ನ್, ಏನು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ಅವರು. ಮತ್ತು 1.5 ವರ್ಷ ಜೊತೆಯಲ್ಲಿ ಸಂಸಾರ ಸಾಗಿಸಿದಿರಿ, ಗಂಡ ಹೆಂಡತಿ ನಡು ಏನು ಏನ್ತು ಗೊತ್ತಿಲ್ವಾ? ಗೊತ್ತಿರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. And you are seeking anticipatory bail. You are not prepared to give a explanation to any of these aspects. And you are putting forward the ground of parity. ಅದನ್ನ ನೀವ್ ಹೇಳ್ಬೇಕು. ನಿಮ್ ಗಂಡ ಈ ರೀತಿ ಯಾಕೆ ಬಿಹೇವ್ ಮಾಡ್ತಿದ್ದ? ಅವ್ನ್ ಬೇರೆ ಏನ್ರೆ ವಿಷಯಗಳಲ್ಲಿ ಏನ್ರೆ ತೊಂದ್ರೆ ಇತ್ತು, ಮೆಂಟಲಿ ಅಪ್ಸೆಟ್ ಆಗಿದ್ದ, ಯಾವ್ದಾರ ವ್ಯವಹಾರದಲ್ಲಿ ಏನಾದ್ರು ತೊಂದರೆ ಮಾಡ್ಕೊಂಡಿದ್ದ, ಕೆಲಸದಲ್ಲಿ ತೊಂದರೆ ಮಾಡ್ಕೊಂಡಿದ್ದ, ಅಥವಾ ವೆರಿ ಸೆನ್ಸಿಟಿವ್ ಇದ್ದ, ಪೊಸೆಸಿವ್ ಇದ್ದ? ಇದನ್ನ ಹೇಳ್ಬೇಕಾದವರು ನೀವು ಅದನ್ನೊಂದು ಕತೆ ಹೇಳಲ್ದ ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಹೇಳ್ಬೇಕಂತ ಹೇಳ್ತೀರಿ. ಸೊ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ಆರ್ ನಾಟ್ ದಿ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್. ಒನ್ ಆಫ್ ದಿ ಅಲ್ರಿ, ಯು ಆರ್ ಎ ಲೈಫ್ ಪಾರ್ಟ್ನರ್. ಏನ್ ವರ್ಡ್ ಯೂಸ್ ಮಾಡ್ತೀರಿ ಸರ್? ಐ ಆಮ್ ನಾಟ್ ದಿ, ಐ ಆಮ್ ಓನ್ಲಿ ಎ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್. ಯು ಆರ್ ಎ ಲೈಫ್ ಪಾರ್ಟ್ನರ್ and you are putting you in the status of a only family member. Nothing, no other serious relationship. ಏನು ಸರ್, 1.5 ವರ್ಷ ಜೊತೆಯಲ್ಲಿ ಸಂಸಾರ ಮಾಡಿದಿರಿ, ಗಂಡನ ಬಗ್ಗೆ ನಿಮ್ಗೆ ಏನು ಗೊತ್ತಿಲ್ವಾ? ನೀವು ಇನ್ಸಿಡೆಂಟ್ ಆಗೋ ಟೈಮ್ದಾಗ ಎಲ್ಲಿದ್ರಿ ಇಸ್ ನಾಟ್ ಎ ಕ್ರೈಟೀರಿಯಾ. ಪರ್ಮನೆಂಟ್ ಮದುವೆ ಆದ್ಮೇಲೆ ಪರ್ಮನೆಂಟ್ ಆಗಿ ನಿಮ್ ತಂದೆ ತಾಯಿ ಮನೆಯಲ್ಲಿ ಇದ್ರಾ? ಇಲ್ಲ. ಗಂಡ ಹೆಂಡತಿ ಜೊತೆಯಲ್ಲಿದ್ದು ಯಾವಾಗಾದ್ರೂ ನಿಮ್ ತಂದೆ ತಾಯಿ ಮನೆಗೆ ಹೋಗ್ತಿದ್ರಿ, ಅವನೇ ಬರ್ತ ಹೋಗ್ತಿದ್ದ, ಕರ್ಕೊಂಡ್ ಬರ್ತಿದ್ದ. ಸೊ ನಿಮ್ ಗಂಡ ನಿಮ್ ಮೇಲೆ ವಿಶ್ವಾಸ ಇಟ್ಟಿದ್ದ. ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಗಂಡನ ಮನಸ್ಥಿತಿ ಹೇಗಿದೆ ಏನಂತ ಹೇಳ್ಬೇಕಾದವ್ರು ನೀವು. ಅದು ನೋಡ್ಬಿಟ್ಟು ನಾನು ಆ ಸಮಯದಲ್ಲಿ ಇರಲಿಲ್ಲ, ಒಂದ್ ಹಿಡ್ಕೊಂಡು ಕೂತಿದ್ದೀವಿ, ಅದಕ್ಕೆ ನೀವು ಕಸ್ಟಡಿಗೆ ಬನ್ನಿ, ಹೇಗಂತ ಹೇಳಿ ವಿಚಾರ ಮಾಡೋಣ. ಏನು ವುಮೆನ್ ಇದ್ರೆ ಹೀನಿಯಸ್ ಅಫೆನ್ಸ್ಗೆ ಎಕ್ಸಾಮ್ಷನ್ ಇದೆನಾ? ಚೆನ್ನಾಗೇ ಇದ್ರೆ ಏನೇ ಚೆನ್ನಾಗಿದ್ದಿದ್ದು ಒಂದು ಹೇಳ್ತೀರಿ, ಅವ್ನ ತೊಂದರೆಗಳು ಹೇಳಕ್ ಈ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು. ಯು ಆರ್ ನಾಟ್ ಅವೈಲೇಬಲ್ ಫಾರ್ ಇಂಟ್ರಾಗೇಷನ್. ಹಂಗಿದ್ರೆ ಸರೆಂಡರ್ ಆಗಿ ಇಂಟ್ರಾಕ್ಷನ್ ಆಗ್ಲಿ, ದೆನ್ ಕಮ್ ವಿತ್ ರೆಗ್ಯುಲರ್ ಬೇಲ್. ಇದ್ರೆ ವುಮೆನ್ ಇದ್ರೆ ಕಸ್ಟಡಿ ತಗೊಳ್ಬಾರ್ದ? ಅದ್ರಾಗೂ 30% ರಿಸರ್ವೇಶನ್. ವುಮೆನ್ ಅಂದ್ರೆ 30% ರಿಸರ್ವೇಶನ್ ಹೀನಸ್ ಕೇಸ್ಗಳದು. Then surrender. Yes, what you have to say? Either voice recorder conversation, whether it is produced. I'm simply asking. when a voice recorder is there, the IO must have seized the voice recorder, download ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ WhatsApp ಮುಖಾಂತರ. He is required to produce it in manuscript. What is the script of the voice recorder? Simply ಕೇಳಿದ್ದೀನಿ. Correct. ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಹೇಳುತ್ತೆ ಇವರೇ ಕಾರಣ. ಯಾವ ಕಾರಣಕ್ಕಾಗಿ? ಅವ್ರು ಏನು ಹೇಳೋದು ಇಲ್ಲದೆಲ್ಲ ಕತೆ ಹೇಳ್ಕೊತ ಕೂತಿದ್ದಾರೆ. ಏನು ಸ್ಟ್ರೆಸ್ ಮಾಡ್ಬೇಕು ಅದೇ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. ಇದೇರು ಗಂಡ ಹೆಂಡತಿ ಚೆನ್ನಾಗಿದ್ರು ಅದೊಂದು ಹಿಡ್ಕೊಂಡು ಕೂತ್ರು. ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಕಂಟೆಂಟ್ಸ್ ಬಗ್ಗೆ ತಲೆನೇ ಕೆಡ್ಸ್ಕೊತಲ್ಲ ಮಾರಾಯರು. Now I am asking you simple question. What is the reason given so as to attract the ingredients of 107? They assert that they are the cause. Okay, fine. They may be the cause. In what way? ಮನೆಯಲ್ಲಿ ಜಗಳ ಆಗ್ತಿತ್ತಾ? Illicit relation, that is not the allegation made in the voice recorder. Where is that allegation? Voice recorder, that was subsequent allegation made by the family members. That was not made by the deceased when he recorded voice recorder. ನಾನು ಅದಕ್ಕೆ ಕೇಳ್ತೀನಿ, ಒಬ್ರು ಸಾಯಂಕಿತ್ತ ಇವ್ರ ಕಾರಣ ನನಗೆ ಅಂತ ಹೇಳಿ ಬರ್ದು ಹೋಗ್ಬಿಟ್ರೆ ಅವರೇ ಕಾರಣನ? ಕೋರ್ಟ್ ಒಳಗೆ ಕನ್ವಿಕ್ಷನ್ ಕೊಡ್ತಾರೆ. ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ. ಕೋರ್ಟ್ನವರು ಒಂದು ಕನ್ವಿಕ್ಷನ್ ಕೊಡ್ತಾರೆ. ದೆನ್ ಹಿ ಕಮಿಟ್ಸ್ ಸುಸೈಡ್. ಕೋರ್ಟ್ನವರು ಸಜಾ ನೀಡಿದ್ರಿಂದ ನನಗೆ ಮನಸ್ಸಿಗೆ ತೊಂದರೆಯಾಗಿ ನಾನು ನಿರಪರಾಧಿ ಇದ್ದಿದ್ದರಿಂದಲೂ ಅಂತ ಹೇಳಿ ಒಂದು ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ. ಕ್ಯಾನ್ ವೆದರ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಟ್ರೀಟೆಡ್ ಆಸ್ ಎ ಅಬೇಟ್ಮೆಂಟ್? ನಾನು ಅದಕ್ಕೆ ಯುವರ್ ಎಂಟೈರ್ ಕೇಸ್ ಇಸ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ವಾಯ್ಸ್ ರೆಕಾರ್ಡರ್. Voice recorder, except uttering the names, what is the relationship between them? In what way they are caused? In what way, at least, in what way they have abated or instigated so that deceased is capable, has forced to take such a drastic step? Let us accept as what? Okay, let us accept that they had illicit relationship, extramarital relationship between the petitioner and accused number 2. Whether it amounts to abatement. Now I'll go one further step. You are not answering my question. Let him knowledge that is not my question. He had knowledge and these two persons are having extramarital relationship. Let us presume that with the notice of the deceased, they have maintained, whether it amounts to abatement. So nan keliddu, see, when it is suicide, when you are incorporating 306, ingredients of 107 are required to be proved. Let us even accepting the relationship. Our relationship ide. It is known to that person for various reasons. They continued their relationship. Whether it amounts to abatement, because he has got a different remedy under the law to seek a dissolution of marriage, he commits suicide. Whether it falls within the purview of ingredients of 107 is a question. If abatement doesn't fall, 306 parallel. It may only maximum 490 agata. It may cause mental distress is different. Abatement and instigation is different. What the 107 says, noting, you are aware. Huh? It should be any act or omission, then ಅದನ್ನ ಒಂದು ಕತೆ ಬಿಟ್ಟು ಉಳ್ಕಿದ ಎಲ್ಲ ಹೇಳ್ಕೊಂಡು ಅದಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಾನು. That is the reason for your ground I am rejecting your petition. ನಾ ಇನ್ನೇನ್ ಕತೆ ನಾನು ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಆ ಕತೆ ರಿಪೀಟ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ, but I am rejecting your petition. The petitioner has filed the petition under section 438 of CRPC seeking anticipatory bail in Bangalore Rural Railway Police crime number 128 of 22, registered for the offence under section 306, read with section 34 of the IPC. The that the petitioner was married to the deceased about 1 year back, and subsequently he committed suicide. By coming under the moving train on 28/8/22 between Hirehalli and Nidavandi railway station. Initially, UDR case 160 of 22 under sections 174 of CRPC was recorded, and later on the complainant has lodged a complaint on 29/8/22 alleging that the deceased, the petitioner and accused number 2 having maintained illegal relationship are cause for the death of her son, and as such the matter was registered in crime number 128 of 22 for the offence under section 306 of the IPC. The petitioner, apprehending her arrest, has approached the learned session judge, and learned session judge has rejected her bail petition. Hence, the petitioner is before this court. Having heard the arguments advanced by the learned counsel for petitioner, and having heard the arguments and perusing the records, there is no serious dispute of the fact that deceased was the husband of the petitioner, and he committed suicide by coming under a moving train. As per the case of the prosecution, he has sent a WhatsApp voice message wherein he alleged that the present petitioner and accused number 2 are cause for his death, and they are required to be punished. The complainant all along in her complaint alleged that the petitioner is having illicit relationship with accused number 2. It is asserted that because of this extramarital relationship, the deceased was upset and he has taken the drastic step of committing suicide. Section 107 of IPC deals with the abatement or ingredients, which reads as under. Hence, to attract the provisions of 306 IPC, the ingredients as referred in 107 of IPC as required to be proved by the prosecution. In the present case, there is a simple allegation that the petitioner and accused number 2 were having extramarital relationship and it was within the knowledge of the deceased. However, the alleged voice recorder said to have been sent by the deceased does not disclose this aspect, and it simply asserts that the present petitioner and accused number 2 were cause for his death and they are required to be punished. But the voice recorder, the voice message did not give any reason as to what are the grounds and in what way they are concerned for death of the deceased. Considering these aspects, at this juncture, there cannot be any presumption that the death is because of this alleged abatement. No doubt the matter is still at the stage of investigation and the investigating officer is required to collect the material evidence. However, except the voice message at this juncture, there is no other material evidence forthcoming. The ingredients of 107 of IPC are not at all forthcoming at this stage, merely because merely on the basis of allegations that there were extramarital relationship between the deceased, between petitioner and accused number 2. It cannot be presumed that the ingredients of section 107 are attracted. Looking to these facts and circumstances, in my considered opinion, petitioner can be, the petitioner is a woman and also research. For these circumstances, looking to the facts and circumstances, I do not find any impediment for admitting the petitioner. The other offences raised by learner SCP can be meted out by imposing certain conditions. Hence, 1 lakh, 1 surety rejected. So you are pleased to see that it is rejected. Very good. Learner counsel for petition called out absent. Please chapter 3 weeks. What is the status of this present petitioner? Accused number? A1, he is A1. A1 and A4.
ఇది ఎక్కువ ట్రైన్ ఉన్నట్టు there's a segregation and the materials are also there. Most of them.
Suppose that civil litigation is also pending between them. Is the requested the hearing counsel for petitioner. Is the matter on first.
Something has been created when we think back. Again, you're supposed to agree to the operating.
Wait 1 minute. Victim is not represented. She is not represented. No power is filed. Notice is to victim is not issued. See, notice is not yet issued, sir. Somebody, the minor guardian of the victim is required to be represented by somebody else. I have not issued notice. Straightway she is appearing. I'm no way concerned, madam. If you are filing power, then I'll consider it. I cannot identify that lady. Who has to identify? Because I have not yet issued notice. The matter is set down for paying PF to issue notice to R2. You have not paid PF. And straightway the victim is, the minor guardian is present. And how can I understand, know that she is the minor guardian of the victim? Correct, sir. Nana adra bagge de. See, power hakala, who is to identify her? See, you without filing power, you want to submit everything. Sir, ನೀವು bail application ಹಾಕಿ ನಂದು ಏನು ತಕರಾರಿಲ್ಲ. See, technically, it should be, see, she was not issued notice. She appeared. ಕೇಳಿ ಮೊದಲು ನಂದು ಕೇಳಿ, ನಿಮ್ದು ಹೇಳುದು ನನ್ನೇ. I'm not coming in your way. See, basic, BPF ಕೊಡ್ಲಿಲ್ಲ, okay. She wants to appear voluntarily. She should be represented by the council. Council wants to submit, you want to submit, but she is unrepresented. Who has to identify her? She is the victim ಅನ್ನೋದಕ್ಕೆ, she is the minor guardian identify ಮಾಡೋರು ಯಾರು? Some council should file power ಅಲ್ಲ. Power ಹಾಕಿ ಮಾತಾಡಿ, ನಂದೇನು ತಕರಾರಿಲ್ಲ, ತೆಗೆದಿಟ್ಟಿದ್ದೀನಿ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ದೀನಿ, ಪವರ್ ಹಾಕಿ. If I am correct, the petition filed by A3 was rejected by this court. The property was stolen, the sandalwood tree is alleged to have been uprooted by you. As per the allegations, you have disposed of. They, at your instance, the property was recovered from the custody of A3. A3 bail petition is rejected. Now, how at the juncture when the matter is still at the stage of investigation, arrest acted. ಅದೆಲ್ಲ ಆಯ್ತು ಕೆಲ್ಸ. See, whatever it may be, I am not concerned. See, 104D ನೋಡಿ first ಅದ್ರ ಬಗ್ಗೆ ಹೇಳಿ ಅಷ್ಟೇ. 104D ಬಗ್ಗೆ ರಿಪ್ಲೈ ಕೊಡ್ಬೇಕು first. A negative burden is there. Matter is still at the stage of investigation. This is too early to come to a conclusion when that the stolen property, sandalwood billets were recovered at your instance from the one of the other accused. The recovery was already done. A measure was drawn. Presumption under section 104D. Then how you stand in now on a different footing? That was rejected because he was in possession. So it was disputed, but the possession, it is specifically observed in that case that the recovery was at the instance of you who was found in possession.
There's no identification photos.
Those are the secondary investigation. You are arguing final. So if arrest is doubtful, recovery becomes doubtful, then there was no need for you in custody. Arrest doubtful andre nanage helilla. ರಿಕವರಿ ನಮ್ಗೆ ಆಗಿಲ್ಲ ಏನಂటే ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು ನಮ್ಮ Sir, 104D. Initially, at this juncture, because matter is at the stage of investigation, unless you produce a material evidence to prove your innocence by way of negative proof, you're not entitled for bail. That too, when prosecution seriously opposes, that are the wordings there. When first condition is prosecution must be given an opportunity, it should be heard. If prosecution objects seriously, then the second issue will be, if court comes to a conclusion that you are not guilty of the offense, a negative burden. Now this is too early. After submission of charge sheet, you can take a check. The learned counsel for petitioner submit that he may be permitted to withdraw the petition with a liberty to move before the concerned court after submission of the final report. The submission is placed on record. The petition is dismissed as withdrawn with a liberty as prayed for. (354) outraging the modesty. 354A, sexual harassment of the nature of unwelcome physical contact and advance or demand or a request for sexual favors showing pornography. 354A, sexual harassment of the nature of making sexually colored remarks. 1 year over. 354 is only non-billable. And 506 are non-billable. 354A is billable. Yes.
The issue is that the other of the reason to maintain it or some request to give glucose. Glucose was administered 9 o'clock, 9 p.m. Patient 9 a.m. ಚಿಕಿತ್ಸೆಗಾಗಿ ದಿನಾಂಕ 28ನೇ ಸೆಪ್ಟೆಂಬರ್ ಸಮಯ ವಾಸನೆ ಮಾಡಿ after that 29 she once again comes to me. ಆ ಸಮಯದಲ್ಲಿ ನನಗೆ ದುಃಖ ನಾನು ಸುಮ್ಮನಾದೆ ಉದನೆ ಮಾಡಲೇ ಇದ್ದೀನಿ 29ನೇ ಅದೇ ವೈದ್ಯರ ಅದೇ ರೀತಿ ಕೆಟ್ಟದ್ದು. These are the two allegations found. 28 and 29 patterns. Once again she visits on 30th. ಆ ಸಮಯದಲ್ಲಿ ಅಲ್ಲಿ ಯಾರಾದರೂ ಇದ್ದು ಅವರನ್ನು ಹೊರಗಡೆ ಕಳುಹಿಸಿ ಸಭ್ಯವಾಗಿದ್ದರು ನಾನು ಎದುರಿ ಯಾರಿಗೂ ಹೇಳಲಿಲ್ಲ. Next is on 30th, she once again visits my clinic.
serious allegations are of that of
He is a doctor behaving with a patient in such a way. I do not know the, but allegations, only I am talking about allegations, but not befitting to a doctor on whom a trust was posed. If such things commit by doctors, nobody will go to any doctor.
Lawyer and a doctor are two people whose competence and trust. Only submission is for 3 days continuously they come for glucose, and apprehension is that I might tamper the witness and evidence. She is the only person who is the victim, is the only person whose statement is there on record. Section 4 dismisses my application saying that I might tamper the witnesses. There's no witness tamper as such, or there are any instruments or any evidence. If conditions are imposed on me by us, I will apply and cooperate. That is all what I can tell.
Did you lodge a complaint? क्या कहता है नहीं, you know it. Did you lodge a complaint against the brothers of the victim complainant?
No,
Because there is a specific allegations that they have smashed you.
I did not lodge it. Because my lord knows that doctor's profession is one delicate profession which has been doing both COVID and all these things. They have been targeted, but this is one such case is my respectful submission. That is what my.
No, it is after COVID, and a doctor was assaulted by the brothers on the same ground. In such matters, we cannot expect instant. Yes, what you have to say? ಈಗಾಗಲೇ ಅವನು ಹೊಡೆದ್ ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ಸಿಕ್ಕಾಪಟ್ಟೆ ಒಂದೇ ಊರಲ್ಲಿ ಮೆರವಣಿಗೆ ಮಾಡಿ ಒಂದು
The conditions could be.
Petitioner has filed this petition in section 438 that seeking anticipatory bail in the event of his arrest in Chandra Labor crime number 302 of 22, registered for the offences punishment 354A, 506 and 354 of the IPC. The brief factual matrix leading to the case heard the learned counsel for petitioner learned HCGP for respondent state. Where is the records? The brief factual matrix leading to the case that the complainant was suffering from stomachache, and as such, she had approached for treatment to petitioner on 28/9/22 and 29/9/22. It is on 30, 28, 29 and 30. There it is. During the said visit, the petitioner has misbehaved with the complainant by touching her body with a different intention and threatened her not to disclose the same, and also kissed her. Subsequently, the complainant has refused to take treatment from the present petitioner, and she was treated by a different doctor, and she recovered from her illness. Later on, the complainant has disclosed the issue before her mother and brothers, and the brothers approached the petitioner and have manhandled him. In this regard, the complainant has lodged a complaint. On the basis of the complaint, crime came to be registered in crime number 302 of 22 for the above referred offences by issuing FIR. The petitioner apprehending his arrest has approached the learned session judge seeking anticipatory bail, but his bail petition came to be rejected. Hence, the petitioner is before this court. Are you doctor? Let me know, get confirmed.
There's a certificate. He's a doctor.
Because lot of fake doctors are no.
Certificate also. FIR certificate.
FIR certificate illa, number illa.
In the complaint itself. Real clinic.
It is a clinic.
It's a clinic.
It is a clinic. You are a certified doctor. ಅಂತೂ ಏನೂ ಇಲ್ಲ. ನೀವು ಯಾಕಂದ್ರೆ ನನಗೆ ಡೌಟ್ ಬರಕ್ ಕಾರಣ, you did not disclose your status as a doctor so and so. You simply referred by name without disclosing your status as a doctor. The name of the petitioner nodi. You have not mentioned him as a doctor.
What I can produce the document.
Allah, that is a different aspect. That is not been prosecuted. That is a different aspect. But you are not disclosed the profession as medical practitioner.
As the Lord said, it is.
He is not doctor so and so. Profession medical practitioner illa. Simple so and so XYZ address. Other son of residing at so and so. That's all.
Really, ತೋರ್ಸಿದಂಗೆ FIR ಅಲ್ಲಿ ತೋರ್ಸಿದಂಗೆ ಅದನ್ನ ತೋರ್ಸಿ.
ನೋಡ್ಬೇಕಲ್ಲ ವಕೀಲ್ರೆ, you should
Actually, it's not the allegation also.
Allah, it is not allegation, but during the course of the investigation, it will also come into play.
I could produce all the documents to the investigation.
This bail petition came to be registered and notified.
Having heard the argument and perusing the reports, it is the allegations disclose that the present petitioner is a medical practitioner, and on 28th, 29th and 30th September 22, the petitioner approached him for certain treatment as he is suffering from stomach pain. It is alleged that during the said period, he has misbehaved with him and later on 39/22, he has also kissed her by touching her body. Hence, this complaint came to be lodged on 3/10/22. It is alleged that when the complainant on second brought it to the notice of her mother and others, they have assaulted the present petitioner. However, it is evident that the petitioner has not lodged any complaint in respect of assault on him. The allegations were regarding outraging the modesty, and the offences alleged against the present petitioner are under section 354A, 354 and 506 IPC. 354A IPC is bailable, while the other two offences are non-bailable. But however, they are triable by the learned session judge. The petitioner is alleged to be a practicing alleged to be medical practitioner, and question of he absconding or fleeing away from justice does not arise at all. Further, it is submitted that 164 statement of the victim is already recorded, and hence question of tampering the prosecution witness is also not possible. Looking to these facts and circumstances, in my considered opinion, there is no impediment for admitting the petitioner on bail, anticipatory bail. The other apprehensions can be present with 140 attendance first and 15th. The learned counsel for petitioner submitted needful has been done. Office to verify and issue notice to respondent number 2. This is the matter. ನಿಮಗ PF ಕೊಡಬೇಕಾದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಇರಲಿಲ್ಲ, ಕೋರ್ಟಿಗೆ ಬಂದ ಕೂಡಲೇ ಅರ್ಜೆನ್ಸಿ ಆಗುತ್ತೆ. It is to be served in Kodagu. It will take its own time. This is the matter on 7th, 7/12.
The crystal wave, patients later. And then 2 days.
But you are not implicated victim. You are not made victim as a party. 376 offense. What 439 says. Yes, that is not applicable to you. 376 subclause 3. It is pertaining to rape on a child aged about 16 years. Covered under section.
Associate relationship. As the petitioner and the first employment colleagues working in a private spouse. As they would fell in love. But on 13/5/2022, allegedly the petitioner would take the first employment by saying that we'll roam around and come back to take the rest of the lodge. And they would go to the lodge. The name of taking rest. And thereafter he goes on her by promising to get her back. This is a nutshell. Thereafter, refuse to marry. But on the basis of this complaint, the petitioner can be arrested and arrested, and his initial custody is 1794. But now, investigation is completed. After filing the petition, already investigation is completed. And the first instance, they would believe that promise to marry and not married. But how come the charge sheet to indicate and to retract is married? I refuse to leave it me. But against the wishes of the family members, retract marriage with marriage. As to the petitioner has to take arrangements, get back on the normal balance not. Our lordship is getting it. This could be charged in page 4, relevant in page 7.
Yes.
Page 9 letters, 40 letters. With that, Akashic column 17. Ask attention. ದಿನಾಂಕ 8/6/2022 ವಿದ್ಯಾಲಮ್ಮ ದೇವಸ್ಥಾನಕ್ಕೆ ಆರೋಪಿಯು ಸಾಕ್ಷಿ ಒಂದರವನ್ನು ಮದುವೆಯಾಗಿದ್ದಾರೆ. ನಂತರ ಆರೋಪಿಯ ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ ನಾನು ಒಂದು ವಾರದಲ್ಲಿ ರೂಮ್ ಮಾಡಿದ್ದೇನೆ. ಈಗ ನೀನು ನಿಮ್ಮ ತಂದೆ ತಾಯಿ ಮನೆಗೆ ಹೋಗಿ ಮತ್ತೆ ಆರೋಪಿಯು ಸಾಕ್ಷಿ ಒಂದರವನ್ನು ಬದಲಿಸಿಕೊಂಡಿರುವುದು. ಸಾಕ್ಷಿ ಒಂದರವರು ಆರೋಪಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗುವ ಆರೋಪಿಯ ನಿಮ್ಮ ಜೊತೆ ಆರೋಪಿಯು ಸಾಕ್ಷಿ ಒಂದರವನ್ನು ಮದುವೆಯಾಗುತ್ತೇನೆ. ಸಾಕ್ಷಿ ಒಂದರವರ ಮೇಲೆ ಬಾರಿ ಬಾಯಿಗೆ ಬಂದಂತೆ ಮದುವೆಯಾಗಿ ಸಂಸಾರ ಮಾಡದೆ ಮೋಸ ಮಾಡಿ Impede 61%. Spot of the marriage, they have even drawn consent. ಬಂಗಾಳು ಪುಸ್ತಕ ಬೇಕಾಗಿದೆ. 61 ಬಂಗಾಳು ವೇಳೆ ಆರೋಪಿ ತಾಳಿ ಕಟ್ಟಿದ ಸ್ಥಳವನ್ನು ಬಂಗಾಳು ಪೊಲೀಸ್ 57 page 57 and 58 photographs indicating the marriage between first comment and now charge sheet is complete, investigation has been completed. This should indicate that for some other state institution reasons is not really by the complaint in the first instance, that by promising the customer you got to tell and had relationship. But it appears to be that is said to show that relationship between the parties are sincere in nature. Certainly would not weapons made and weapons is the areas apprehension of constitution may indulge in the constitution. All that would not arise in the investigation. This is an engaged person. Only stand for parents. Things will be delayed. But he is working in the government's factory and has to this 2 months already is in the stage. But by putting it in the stringent conditions, we can draw the thing.
Yes. Yes. When the complaint is lodged, complaint is lodged on 16/9. Why the subsequent events which were part of 164 statement were not incorporated in complaint? Her marriage, termination of her pregnancy, And her 164 statement disclosed that marriage was got performed by the police themselves. ಆಯ್ತ್ರಿ June ಒಳಗೆ pregnancy ಆಗಲಿ, you lodged a complaint in the month of September. 16/9/22 you lodged a complaint, a neatly typed complaint dated 16/9/22. Their only allegation is regarding rape under the promise of marriage. But by that time, the marriage was already performed, which is disclosed in 164 statement, not in the complaint. Why? Including termination of pregnancy. She has gone to the extent of asserting that police are also supporting him. They have compelled her to take the pills for termination of the pregnancy. Huh? Sir, 16/9 complaint ಕೊಟ್ಟಿದ್ದೀರಿ, 17/9 164 statement record ಆಗಿದೆ. 16/9 complaint ಕೊಟ್ಟಿದ್ದೀರಾ. Very next year 164 statement was recorded. What is not there in one complaint? All are narrated in 164 statement. Why they were not narrated in her original complaint ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. Regarding marriage concealed, conceiving is concealed, termination is concealed. ಏನೇನು ಇಲ್ಲ ಅದರಲ್ಲಿ.
The documents is 30 minutes. Still documents, page 30. On 15 bottom line, and it is. Informant check up in form to be seen. Donor Aga, check up. The history in run language told that he and Harish working in India EMS company became friends. Then it when used to turn into love, both looking to each other. Since 1 year, we just had we had sexual relations for 4 to 5 times in a month. Then I became pregnant and went to home. Then my parents got back. We married. Took tablets for medical termination. Include 8 termination. Then, but Harish's mother it disliked this marriage. So when I transitioned to move to my native, I was at my native.
Already in the complaint allegations notiದ್ರೆ, the relationship started from 13/5/22 onwards. Though they were 1 year in the ಪರಿಚಯ ಇದ್ರು, but the allegations in the information given before the doctor said for 1 year they are maintaining the relationship and monthly meeting 4 to 5 times. In complaint 1 allegation, doctor a different allegation, 164 entirely different way. Yes, you want to add anything? That is correct. ಅದ್ರ ಬಗ್ಗೆ ಏನಿಲ್ಲ. ಇವೆಲ್ಲ assertions, one assertion is made before the medical officer. Complaint a different assertion. 164 statement entirely different. Three different statements which is to be accepted. I'm not coming, I'm not. The relation is undisputed. But her allegation that first time they had a physical relationship on 13/5, that becomes a false statement in view of the statement, the medical statement. Huh? See, one thing is certain. After detecting her pregnancy, they were married. That is evident from her 164 statement. They first time met on 13/5.
Parents involved in that.
No day. And within 1 month, pregnancy cannot be detected. 13/5 they met. First physical relationship on 13/5. And allegation is that she became pregnant and she went to police station and other things. Then police got married on 8th June. Within 4 weeks, pregnancy detect agata. As per medical prudence, because cycle is to be completed. Then this statement is not actual statement. The statement given before the medical officer appears to be more reasonable because they were having a physical relationships last 1 year only. It is 1 month aglilla, 30 days aglilla, hardly 25 days. Because 13/5 they met. And before 8th, pregnancy was found. And after certain negotiations, marriage was performed by the police. So within 3 weeks, virtually, whether 3 weeks pregnancy can be detected, not possible. Then the statement given, history given before the medical officer is correct. That is a different aspect. Wherein she stated that since last 1 year, every month they are meeting. ನಾನು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಈ ವೆದರ್ ಈ 13/5 ಮೀಟ್ ಆದ್ರೆ ಅವರು ಫಿಸಿಕಲ್ ರಿಲೇಷನ್ ಮಾಡಿದ್ರೆ ಬಿಫೋರ್ 5th June ಮುಂಚೆ ಪ್ರೆಗ್ನೆನ್ಸಿ ಟೆಸ್ಟ್ ಪಾಸಿಟಿವ್ ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆನಾ? ಮಿನಿಮಮ್ 1 ಮಂತ್ ಆಗ್ಬೇಕು. ಪ್ರೆಗ್ನೆನ್ಸಿ ಟೆಸ್ಟ್ ಪಾಸಿಟಿವ್ ಬರ್ಬೇಕಾದ್ರೆ ಇಲ್ಲಿ 1 ಮಂತ್ ಆಗ್ಲಿಲ್ಲ. How she presumed that the pregnancy was tested positive? But that is her statement testing positive is a proper thing. But her allegation regarding they meeting first time 13/5 should be false. And that is again corroborated by the history given before the medical officer, wherein she says that they are meeting since last 1 year. Possibility. Pregnancy, there is no dispute. The issue is when first time they met. All are inconsistent persons. Three statements in a different way. Consensual sex, marriage was performed. Now see, charge sheet is that since he is not taken, he is not prepared to lead marital life. The provisions of SC/ST Act. Things would have been different. The matter would not have come before this court. Matter would have gone before the, by way of appeal. Isn't it? Then mother had a problem, but this person doesn't have any problem. So that may be the reason not for incorporating the provisions of SC/ST Act.
Going by the nature tax credit, this cover will be there. Repeated,
The petitioner has filed the petition, the section 439 of CRPC, seeking the regular bail in Bengaluru District Women PS crime number 76 of 22, pending on the file of additional civil judge and JMFC Doddaballapur for the offences punishment under section 376N and 420 of IPC. We heard the learned counsel for petitioner and learned HCGP for the respondent state. Peruse the records. The brief factual matrix leading to the case are that the present petitioner and accused, present petitioner and the complainant were working in private establishments, and they fell in love with each other. It is alleged that on 13/5/22, the petitioner took the complainant victim for roaming, and thereafter he booked a lodge in Doddaballapura, and there, when they were taking rest, the petitioner came close to her and kissed her, hugged her. Later on, forcible sexual assault was committed on her against her will. However, it is alleged that he assured her of marriage, and as such, on 5 to 6 times, sexual assault was committed under the pretext of marriage. Later on, he did not respond and avoided her. And when she approached her, he refused to marry her, and as such, she was compelled to lodge a complaint on 16/9/22. On the basis of the complaint, the crime came to be registered for the offences punishment under section 376N and 420 of IPC. The petitioner was apprehended and was remanded to judicial custody. In between, the statement of the victim was also recorded before the magistrate under section 164 of CRPC. And after completing the investigation, the investigating officer has also submitted the charge sheet against the accused petitioner for the above alleged offences. For the offences punishable under section 323, 376N, 420, 498A, and 504 of IPC. Next. Having heard the arguments and perusing the records, it is evident that all along the petitioner has alleged that the accused has committed sexual assault on 13/5/22 for the first time in a Doddaballapur lodge, and later on he refused to marry her. The allegations of the complaint were regarding committing rape under the false promise of marriage, and this complaint was lodged on 16/9/22 itself. Very interestingly, on 17/9/22, the statement of the victim was recorded before the learned magistrate under section 164 of CRPC, wherein she again asserted that on 13/5/22, first time they had physical relationship in Santosh Lodge of Doddaballapur under the pretext of marriage, and later on she has asserted that when she became pregnant, the accused asked her to consume the pills and papaya fruit so as to terminate the pregnancy. It is also alleged that later on, she further stated in her 164 CRPC statement that later on his promise, he left the job, but he continued his job and he started to avoid her. And subsequently, she got pregnancy test done, which has shown positive result, and the police have performed his marriage, the marriage of petitioner and the complainant on 8th June in Mutyalamma temple. Very interestingly, none of these allegations were found in the complaint lodged on 16/9/22, wherein the allegations were that under the pretext of marriage, the rape was committed, but the allegations in 164 statement disclose that subsequently he assaulted her, avoided her, and she became pregnant, and she was married with petitioner in Mutyalamma temple. Interestingly, both the allegations disclose that they met first time, they had physical relationship first time on 13/5/22, but the marriage was alleged to have been performed on 8/6/22 after she testing positive for pregnancy test. Interestingly, when they met first time on 13/5/22, question of C testing positive for pregnancy test before 1 month does not arise at all. Hence, it is evident that the complainant has not disclosed the factual aspects before the court or in her complaint. Next. However, this is clarified by the medical evidence, wherein before the medical officer, she has given history that she and the present petitioner were in love with last 1 year, and in this period they had regular sexual intercourse 4 to 5 times in a month. This statement is completely contrary to the complaint allegations as well as 164 statement. The marriage is also performed and final report is submitted, wherein it is alleged that the petitioner, he has refused to continue marital life with the present petitioner. All these facts and circumstances disclose that it appears to be a consensual sex and marriage was also performed. But the petitioner is now trying, and the complainant is now trying to make out a case that first time she was raped on 13/5/22, which is falsified by her 164 statement regarding pregnancy and the history given before the medical officer. The investigation is also concluded, and it is evident that the complainant has not approached the court with clean hands and she has concealed certain material aspects. Looking to these facts and circumstances and completion of the investigation, in my considered opinion, petitioner can be admitted on regular bail subject to certain conditions so as to counter the apprehensions raised by the learned HCGT. As such, the petition needs to be allowed, and accordingly, I proceed to pass the following order. 1 lakh with 1 surety. ಮಾಡ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ. ಹಾ. It is noticed that the offences alleged against the present petitioner are under section 363, 376 2F, and 506 radio section 34 of the IPC, as well as under the provisions of POCSO Act. Hence, POCSO Act as well as Information and Technology Act. As such, it is mandatory for the petitioner to implead the victim or the minor guardian of the victim as a necessary party, and she was required to be heard as per the second proviso to section 439 subclause 2. Hence, learned counsel for petitioner is directed to implead. What is the age of the victim? The minor guardian of the victim. Who is the law? Who has lodged the complaint? Minor guardian of the victim, and learned counsel is also directed to take appropriate steps for service of notice to minor guardian of the victim. Read the matter on 5th.
Nursi Reddy.
Government counsel for petitioner called out. Reach the matter after 2 weeks. ಯಾವ್ದಿದ್ರು ಅಷ್ಟೇ ನಾವು ಮುಂದೆ ಬರಬೇಕು, ಅವ್ರ ಆಮೇಲೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ರಿಲೀಸ್ ಮಾಡಬೇಕು.
My lord, I appear for petitioner, my lord. My lord, I kindly seek for a pass over, my lord. Kindly matter may be taken up at 2:30, my lord.
Why, sir?
My lord, arguing counsel is held up in some other court, my lord. Kindly matter may be taken up at 2:30, my lord. Physically will be appearing before your lordship. Your lordship has heard this matter in depth, my lord. The victim family was also present. Obliged.
I cannot entertain memos at any time. Memos will be entertained at 10:30 AM. No, sir, I cannot change the rule for one. Discrimination ಮಾಡಿದಂಗೆ ಆಗತ್ತೆ, ತಪ್ಪಾಗತ್ತೆ. No, sir, I cannot. Memos can be moved only once in the morning. ಯಾವಾಗ ಬೇಕಾದಾಗ ಮೆಮೊ ತಗೋಕ್ ಹೋದ್ರೆ then there is no law and order. ಆಯ್ತು, ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಕೊಡಿ, ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನೀವು. And that is a different aspect. ಬೆಳಿಗ್ಗೆ 8:00 ಎಲ್ಲ ಮೆಮೊ ಫಸ್ಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋದೇ ನಾವು ಮೆಮೊ ತಗೊಂಡು. First we receive memo, then we will go for adjournment, then we will go for hearing. ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ ಕೊಡಿ ನೀವು, no problem. Entertain your memo, I will not come. But ಒಬ್ಬರಿಗೆ ನಾನು ಆಟ್ ಟೈಮ್ ದಾಗ ತಗೊಂಡೆ ಅಂತಂದ್ರೆ ಎಲ್ಲ then it will be made as a precedent. I don't want to create any precedent. ಅವ್ರು ತಗೊಂಡಿದ್ದೀರಿ ನಮ್ ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಹೇಳಿ ಒಂದು ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ. Why? ಅವ್ರದೇ ಸ್ಪೆಷಲ್, ಅವ್ರದೇ ತಗೊಂಡ್ರಿ ನೀವು ಟೈಮ್ ಅಂತ ಕೇಳಿದ್ರಿ. ಸಿ ವಿ ಶುಡ್ ಎಲ್ಲರಿಗೂ ಈಕ್ವಲ್. ಅದಕ್ಕೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ 10:00 ಕೊಡಿ, ಇರ್ಲಿ 10:00 ಅರ್ಜೆನ್ಸಿ ಇತ್ತಂದ್ರೆ 10:30 ನೀವು ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ನೋ ನಾಳೆಗೆ ನಾನು ಹೇಳಕ್ ಆಗಲ್ಲ. ನೀವು ರಿಕ್ವೆಸ್ಟ್ ಇನ್ನ ಮೆಮೊನ ಕೊಟ್ಟಿಲ್ಲ, ನಾಳೆಗೆ ಹೆಂಗ್ ನಾನು ಹೇಳಿ? ನೋ ಸರ್, ದಟ್ ಕೆನಾಟ್ ಬಿ ಡನ್. ಮೆಮೊ ನೀವು ಕೊಟ್ಟ ಮೇಲೆ ವಿಲ್ ಡಿಸೈಡ್. ನೀವು ಮೆಮೊ ಈಗ ಯಾವಾಗ ಬೇಕಾದಾಗ ಸಾಯಂಕಾಲ ಮೆಮೊ ಕೊಟ್ಟು ನಾಳೆ ಹಾಕ್ರಿ ಅಂತ. ಸರ್, ಇದು ಏನಾಗುತ್ತೆ, ನಿಮ್ದು ಅರ್ಜೆನ್ಸಿ ಇರ್ಬೋದು, ಉಳ್ಕಿದವ್ರಿಗೂ ಸಾಕಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಇರುತ್ತೆ. ಅವ್ರು ತಗೊಂಡಿದ್ದೀರಿ, ನಮ್ ತಗೊಳ್ಳಲ್ಲ ನೀವು ಮೆಮೊ, ಅವ್ರಿಗೊಂದ್ ನ್ಯಾಯ ನಮಗೊಂದ್ ನ್ಯಾಯ ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ರೆ ಐ ಶುಡ್ ಬಿ ಇನ್ ಎ ಪೊಸಿಷನ್ ಟು ಆನ್ಸರ್. ಎಲ್ಲರಿಗೂ ಒಂದೇ ನ್ಯಾಯ. ಯು ಶುಡ್ ಟ್ರೀಟ್ ಎವ್ರಿಬಡಿ. ಎಲ್ಲರಿಗೂ 10:00 ಎಲ್ಲರಿಗೂ ಮೆಮೊರಿ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ತೀನಿ. ನೋ ಎಕ್ಸೆಪ್ಷನ್, ಆಮ್ಯಾಗ ಎಲ್ಲ ಎಕ್ಸೆಪ್ಷನ್ಸ್ ಆಗ್ತಾವ. ಸೊ ಬರ್ತೀನಿ, 2:15 ಬರ್ತೀನಿ. 2:30 ಈಗ ನಿನ್ನ ಇದ್ದಿದ್ದೆ ನೋಡೋಣ. 2:15 ತರಿಸ್ಕೊಂಡು ಹೋಗ್ತದೆ. 2:30.
Madam Court Officer. Madam Aura. Madam. Court Officer, Madam. కోర్ట్ ఆఫీసర్ కూడా మ్యూట్ చేసుకొని ఉండాలప్ప. మేడం కోర్ట్ ఆఫీసర్ మేడం. ಮೇಡಮ್
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಅವರೇ 69 ಏನಾಯ್ತು ಮೇಡಮ್? 69 ಮೇಡಮ್.
ಆಬ್ಸೆಂಟ್ ಅಂತ ಹೇಳಿ 2 weeks ಹೋಯ್ತು ಸರ್.
ಹಾ 2 weeks ಆಯ್ತಾ ಮೇಡಮ್? ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಏನ್ ಪಾಸ್ವರ್ಡ್ ರೀ? ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ ಮತ್ ಪಾಸ್ವರ್ಡ್ ಏನಿದೆ? ವಾಟ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್? ವೀಕ್ ಟೈಮ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಬೇಲ್ಗೆ ವೀಕ್ ಟೈಮ್ ಸರ್. ಏನ್ ಅನಕ್ಷರ ಇಲ್ಲ, ಬೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ ರೆಲೆವೆಂಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ ನಾನು. ಕೆನಾಟ್ ಸರ್, ನಿಮಗೆ ರೆಲೆವೆಂಟ್ ಆಗೋದು ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಿಚ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟೆಡ್ ದಿ ಬೇಲ್ ಅಂಡ್ ದೇರ್ ಪೆಟಿಷನ್. ಬೇರೆ ಬಿಟ್ಟು ಬೇರೆ ಏನೋ ರೆಲೆವೆನ್ಸ್ ಇಲ್ಲ. ಹಾ ಮತ್ತೆ ಗೊತ್ತಾಗತ್ತಿಲ್ಲ. And your party is before the court all along. ಮತ್ತೆ
Bail granted by the Sessions Court, madam. The property in Sessions Court have been.
no sir, there is no bar.
Yes.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಅವರು ಕ್ಯಾನ್ಸಲೇಷನ್ ಗೆ.
Cancellation they have filed before this.
ಕರೆಕ್ಟ್ ರೀ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ. ದೇ ಆರ್ ಅಗ್ರೀವ್ಡ್ ಬೈ ದಿ ಗ್ರಾಂಟಿಂಗ್ ದ ಬೇಲ್. ಅದಕ್ಕೆ 439 ಸಬ್ ಕ್ಲಾಸ್ 2 ಕೆಳಗೆ ಬಂದಿದ್ದಾರೆ. 11th ಕೌನ್ಸಿಲ್ ಈ ರಾಜೇಂದ್ರ KR files power for respondent number 2 as a legal aid counsel and place time for filing objection statement. Is the matter on 30th. 30th. Yes, Sukhilda. Yes. ಅವ್ರಿಗೆ ಆಲ್ವೇಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರೋದು, ಇನ್ಫಾರ್ಮೇಶನ್ ಮ್ಯಾಗ ರೇಡ್ ಮಾಡ್ತಾರೆ. ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ರಿ ಅನ್ನೋ adi bekagilla. See, that is not the, they have received certain information that such and such person is carrying some contrabands. Adar ಮೇಲೆ raid ಮಾಡ್ತಾರೆ. He has not disclosed the source of information, further details disclose ಮಾಡಲಿಲ್ಲ. Those are not the criteria, sir. ಹೇಳಿ, what is the case ಹೇಳಿ? ಏನ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ?
Courtesy of the
489B tribal court of session imprisonment till life. 489C is bailable offense.
C is a billable, B is a billable.
Non-bailable imprisonment life is there.
The allegation, the complaint I request is page number 13. Dated 10/8/2022. This is a request given by the SIMO. The police to register the case. One BS Basavaraj, he is a USP. Let's start the complaint. ಈ ಮೂಲಕ ತೆಗೆದುಕೊಂಡು ಪ್ರಧಾನ ಮಾಡುವಂತ ಯಾವ ಅವುಗಳನ್ನು ಕಳಿಸಿ ಮತ್ತು ಕೆಟಿ ಆಂಜನೇಯ ಸೊ ಬಕ್ರಾಜ್ ಸುರೇಶ್ ನಾಯಕ್ ಮಲ್ಲಿಕಾರ್ಜುನ ಬಾಲರಾಜ್ ರಾಮನಗರ 4ನೇ ಮೇ ನೋಡಲಾಗಿದೆ. ಅಲ್ಲಿ ಇಬ್ಬರು ಆಸಾಮಿಗಳು ನಿಂತಿದ್ದು ಒಬ್ಬರಿಗೊಬ್ಬರ ಕಿವಿಯಲ್ಲಿ ಮೆಲ್ಲನೆ ಮಾಡಿ ಶೋಕ ಎಸ್ ಚಂದ್ರಶೇಖರಪ್ಪ ಮೆಕ್ಯಾನಿಕ್ ಯಲಮನಗರ ದಾವಣಗೆರೆಯಿಂದ ತಿಳಿಸಿದ್ದು. ಇವನ ಶೋಧನೆ ಮಾಡಲಾಗಿ 500 ಮುಖಬೆಲೆಯ ಇಂತಹ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿಯ ಹೆಸರು ವಿಳಾಸ ಪ್ರಸಾದ್ ಈಗ ಟ್ರ್ಯಾಕ್ಟರ್ ಚಾಲಕ ಶೋಧನೆ ಮಾಡಬಹುದು. ಇವೆಲ್ಲ ಬಗ್ಗೆ ಎಲ್ಲ ಸೇರಿ ಒಟ್ಟು 340 ಸರಿಗೆ ಅವರ ಮನೆಯಿಂದ ಗೂಡುಗಳನ್ನು ಹೆಸರಲ್ಲಿ ನೋಟು ಮನೆಗಳಿಗೆ ಕಾರ್ಯ ಮಾಡುವುದು ಕಾರ್ಯ ಒಂದೇ ನಂಬರ್ ಇಂದ ಹಲವು ನೋಟುಗಳು ತೆಗೆದು ಬಂದಿದೆ. ಈ ಬಗ್ಗೆ ಆರೋಪ This is allegation case. Immediately on the same day on 10/8/2022, submission to the son of made an allegation against saying quota note observe they are taking a specific quota note xerox ಮಾಡಿ
xerox ಅಂದ್ರೆ quota note ಅಲ್ವಾ? ಅಲ್ಲ, ನಾನು ನಿಮ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. See, one ನಿಮಿಷ, because you said that there is allegation of initial fake note. A xerox note is not a fake note.
Xerox submission xerox note original note ತುಂಬಾ ವ್ಯತ್ಯಾಸ. Xerox paper we cannot take the note paper.
Which paper is used is a secondary. Paper, different paper can Xerox ಅಂದ್ರೆ ಒಂದೇ paper use ಮಾಡ್ಬೇಕಂತ ಏನಿಲ್ಲಲ್ಲ.
But ನನ್ನ ಸಬ್ಮಿಷನ್ ಏನಂದ್ರೆ ನೋಟಿಗೂ ಜೆರಾಕ್ಸ್ ನೋಟಿಗೂ ತುಂಬಾ ವ್ಯತ್ಯಾಸ.
ಅದನ್ನ ನಿಮ್ ಪ್ರಕಾರ as per your say, but correct, but now the property were seized.
I admit, property was seized. I am the submission to the Honorable Court, Your Honor. They have got the information, they have subscribed in the papers. That is in the year, I am the submission to the Honorable Court, Your Honor. Our circle ಮಾಡ್ತಾ ಇದ್ರು ಇಂಥ ವ್ಯಕ್ತಿ ಅದು ಮಾಡ್ತಾ ಇದ್ರು ಕಂಪ್ಲೇಂಟ್ ಜಾಗದಲ್ಲಿ ನಿಂತಿದ್ದು.
Why you are possessing? What is your intention to possess?
My humble submission, Your Honor.
My simple question is, what is your intention to possess them?
It is not my position. It was seized for through me, but it not belongs to us.
Then why you are keeping them in custody? Then it doesn't belong to you. Take notes. You say that it does not belong to you. You are found in possession. Then you disclose that you have prepared it, Xerox it by using a color Xerox.
My humble submission, Your Honor. HP color. They have mentioned the machine. Xerox machine. Xerox machine Allah. That is a printer. It's HP, sorry. ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಎಪ್ಸಾನ್ ಕಂಪನಿಯ ಕಲರ್ ಜೆರಾಕ್ಸ್ ಮಿಷಿನ್ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ನೋಡಿದ್ರೆ ತಿಳಿಸಿದ್ದು that is an allegation. The presumption was gone by the police.
The question is, why did you make Xerox?
ನಾನು ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
Then how the property seized from your custody?
That is a submission. What will happen?
Sir, nim possession mahzar ide alle. When there is a mahzar,
I am a submission, Your Honor. Only to the accuser falsely implicated.
What is the strain relationship? Then how can you say that you are vaguely arguing that everything is a fact? See, what is the strain relationship? Why they should falsely implicate you? There should be some rivalry, animosity. What is that?
That is the main event.
What is that? That is main. What is that main?
I can submit it orally.
See, your oral submission doesn't have any relevance, sir. When the documentary evidence against you, you will have to rebut that.
My humble submission, seeing the entire Panchanama and the complaint, I am the submission before the Honorable Court. There is 500 notes and 200 notes and 100 notes. They are seized to 192 as per the master. And further, they have taken a condition that the Epson color Xerox machine. It is also, they are saying that the print was taken. Here, I am a submission to the Honorable Court, Your Honor, in the complaint. There is no reference with regard to seizing the Xerox machine. And entire investigation of the case, Your Honor, it has to be filed charge sheet only. The entire investigation was completed.
ನಿಮಗೆ ಹೆಂಗ್ ಗೊತ್ತು?
ಈಗ ಇರೋದೇ ಇಷ್ಟೇ ಸ್ವಾಮಿ.
ಅಲ್ಲ ನಿಮಗೆ ಹೆಂಗ್ ಗೊತ್ತು?
ಅಲ್ಲ ವೆರಿಫೈಡ್.
ಅಲ್ಲ ನಿಮಗೆ ಹೆಂಗ್ ಗೊತ್ತು ನನಗೆ ಹೇಳ್ಬಿಡಿ. So you have so much access. Investigation ಯಾವ ಸ್ಟೇಜ್ ಎಲ್ಲ ನಿಮ್ಗೆ ಹೇಳೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು. Then how can you say that investigation is concluded?
The main is the Mazar was already.
Sir, the offense is against the economy of the state. It is very serious thing, and it will completely destroy the economy.
State what we have certainly I have observed the lordship. It is right to the Indian economy. ಈ ಏನಾಗಿದೆ my humble submission because Honorable Court. Entire Mazar or the complaint, there is no reference at all. They are distributing the note.
Chalawani model, okay, accept it. Why you have Xerox it? Why you are holding the possession? What is your intention to possess them?
It is a good fact. You are.
Sir, what is the now I am asking you, what is your intention to possess?
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಬ್ಬರಿಗೂ ಮತ್ತೆ ಐಒಗೂ ಗಲಾಟೆ ಆಗಿದೆ. In that instant, the IO has put it in this case.
So, according to you, IO has Xerox it?
ಇಲ್ಲ, ಅಲ್ಲ.
ನಿಮ್ದು ಹೇಳೋದಾದ್ರೆ ಐನೋ ಜಿರಾಕ್ಸ್ ಮಾಡಿ ನಿಮ್ಮನ್ನ ಬೇಕ್ ಮಾಡಿದಾನಂತ. ಅವನು ಇಷ್ಟು ಕಷ್ಟಪಡೋ ಬದ್ಲಿ ನಿಮ್ಮನ್ನ ಬುಕ್ ಮಾಡೋದಿತ್ತು, ನಾನು ಯಾವ್ದೋ ಒಂದು ಬೇರೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಒಳಗ C02 ಒಳಗೆ ಬುಕ್ ಮಾಡಬಹುದಾಗಿತ್ತು. ಈಸಿ ಅವನಿಗೆ 302 ಒಳಗೆ ಬುಕ್ ಮಾಡೋದು. ಇದನ್ನ ಪ್ರಾಪರ್ಟಿ ಪ್ರಿಪೇರ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಇದಕ್ಕಾದ್ರೆ they will have to take lot of care.
Is that intention?
No, sir.
I'm not.
Sincere matter is investigation, you are not entitled for. Serious, the offense is against the economy of the state. It cannot be taken in a light way. That is not a ground, sir. When you are destructing the economy, your marriage is not a ground. Who knows what is going to happen? Not, sir, that is not a criteria, sir. When the offense is against the state and entire society, it cannot be taken in such a light way. Marriage is emotional tolakagalla. When the marriage solage, entire society will suffer. The moment it starts circulating, it will be not possible to, what is the, from where source na sure kashtaಗುತ್ತೆ ಆಮೇಲೆ. That is not the criteria. After arguing the matter for some time, the learned counsel for petitioner submit that he may be permitted to withdraw the petition with the liberty to file the bail petition after submission of the final report before the judicial court. The submission is placed on record. In view of the submission, the petition is dismissed as not pressed with the liberty as prayed for. Why you have filed two occurrences? Why you have filed two occurrences? Srimati Nidhi has filed power for respondent number 2. Minor guardian of the victim. By name Indra. Same is placed on record. ನನಗೆ ಏನಿದಕ್ಕೆ ತಳ ಕೂಡ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. ಒಂದನೇದು ಸಿ ಕ್ಲೇಮ್ಸ್ ಟು ಬಿ ದೇರ್ ಕಜಿನ್ಸ್ ಅದಾರ. ಒಂದ್ ನಿಮಿಷ ಚೆಕ್ ಮಾಡೋಣ, ನಂಬರ್ ಹೇಳಿ. ಒಂದ್ ನಿಮಿಷ ಯಾಕೆ ಟೆನ್ಷನ್ ಮಾಡ್ಕೊತೀರ? ಅಲ್ಲ ಚೆಕ್ ಮಾಡಿ, ಇಲ್ಲಿ ಸಿಸ್ಟಮ್ಗಳು ರೆಡಿಮೇಡ್ ಎಲ್ಲ ಸಿಕ್ಬಿಡೋದು, ನಮ್ಗೆ ಏನ್ ಟೆನ್ಷನ್ ಇಲ್ಲ. ಹಾ ಎಷ್ಟ್ ನಂಬರ್ ಹೇಳಿ? 98456 of 22.
98456. 9856.
ಹಾ ಏನ್ ಪ್ರೇಯರು? ಯಾವ ಪೆಟಿಷನ್ ಯಾವ ಪ್ರೊವಿಷನ್ ಕೆಳಗೆ ಹಾಕಿದಾರ ನೋಡ್ರಿ. ಸಿಂಪಲ್ 482 ಕೆಳಗೆ ಹಾಕಿದಾರ. ಏನ್ ಸಿಂಪಲ್ ಚೆಕ್ ಮಾಡ 482 ಪ್ರೇಯರ್ ಕ್ರಾಶಿಂಗ್ FIR.
ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. I does not write anything before the court. And you pray.
ಆಯ್ತು, ಅದು ಒಂದಾಯ್ತು. ಒಂದೇ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನನಗೆ, ಇನ್ನ ಅವ್ರನ್ನ ಮಾತಾಡಿಸಿಲ್ಲ. She has appeared without notice. That is secondary. According to you, the victim is admittedly related to petitioner. ಸೋದರ ಮಾವನ್ ಮಗಳೇನೋ ಆಗ್ತಾಳ ಅವಳು, ಕರೆಕ್ಟಾ? They had physical relationship. Child was born. They married. After intimating the family, which they did not entertain, but they married and they started residing independently. And in the meanwhile, she was pregnant. She delivered a baby in Vani Vilas Hospital. These are the one aspect. Vani Vilas Hospital admission admege, why she suddenly lodged a complaint? The complaint should have been at least by hospital authorities on the ground that she is minor. One, correct? Or medical officer. Why the victim has lodged a complaint? Who has persuaded her to lodge a complaint? ಇರ್ಲಿ, ಬಂದ್ ನನಗೆ ಇದು ಕ್ಲಿಯರ್ ಆಗ್ಬೇಕಾಗಿದೆ.
ಅದು ಏನಿತ್ತು ಅಂತ ನಾನು ಡಿಸ್ಕೌಂಟ್ ಸಿಸ್ಟಮ್ ಐತೆ. ಏನಾಗಿದೆ ಅಂದ್ರೆ,
one thing is, in the complaint, she did not make any allegations. Simply, she narrates the factual aspects. She was aged about, they had physical relations, she pregnant, she went to Vani Vilas Hospital. And this fact is reported. Idನ್ನ ಡಾಕ್ಟರ್ ಎದಕ್ಕೆ ಹೇಳಬೇಕಾಗಿತ್ತು ಅವಳು? ಡಾಕ್ಟರ್ ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿರ್ತಾಳ, ವಾಟ್ ಈಸ್ ಹರ್ ಏಜ್, ಪ್ರೆಗ್ನೆನ್ಸಿ, ಗಂಡ ಯಾರು ಅನ್ನೋದು ಒಂದು ಇಂಟಿಮೇಷನ್ ಕೊಡ್ತಾರೆ. Why her complaint was obtained? At the most, what should have been the doctor should have sent a report to the concerned PSI stating that there is a marriage of a child aged about less than 16 years, which infringes the provisions of the section 9 and 10 of the Child Marriage Restraint Act. He should have submitted, and then the IO could have taken necessary steps. Sumoto complaint to ಮಾಡಬಹುದಾಗಿತ್ತು. Then 164 statement would have been relevant. ಇಲ್ಲೇ ಸ್ಟ್ರೇಟ್ ವೇ ಅವಳ ಕಡೆಯಿಂದಾನೆ ಕಂಪ್ಲೇಂಟ್ ತಗೊಂಡಿರಿ. Gone through the hospital, when she is not aggrieved, why she lodge a complaint? Nan ಪ್ರಶ್ನೆ ಅಲ್ಲದೆ. She is not aggrieved. They are residing as husband and wife. Whether it is a violation of child, everything is okay, fine. But she is not aggrieved. The complaint is not lodged by the minor guardian also. The victim complaint ತಗೊಂಡಿದ್ದಾರೆ ಪೊಲೀಸರು. Victim is not at all aggrieved. Correct, everything is okay. 100% ಅದಕ್ಕೆ ಒಪ್ಕೊಳ್ತಾ ಇದ್ದೀನಿ ನಾನು, ಅದಕ್ಕೆ ಪ್ರಶ್ನೆ ಮಾಡ್ತೇನೆ. ಸಿ ಇಸ್ ಎ ಮೈನರ್, ಇಟ್ ಇಸ್ ಎ ಪೋಕ್ಸೋ ಕೇಸ್, child prohibition of the provisions of section 9 and 10 of the Child Restraint Marriage Act. Okay, fine, everything ಒಪ್ಕೋತೀನಿ. ಅವಳು ಅಗ್ರೀವ್ಡ್ ಇಲ್ಲದೆ ಇದ್ದಾಗ ಅವಳ ಕಡೆಯಿಂದ ಕಂಪ್ಲೇಂಟ್ ತಗೊಳ್ಳುವಂತದ್ದು. Irrelevant thing. Correct, we POCSO case. You register madri. I am not coming in your way. You should have registered it sumoto. Why you obtained this minor signature of the minor? Madam, so last paragraph ಓದಿ. ಬೈದ ನಂತರ ಮನೆಯಲ್ಲಿಯೇ ವಾಸವಾಗಿದ್ದೀವಿ, ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ನಮ್ಮ ಅತ್ತೆ ಮಾವ ಇದ್ದರು. ಏನಿದು ನನಗ್ ಬರ್ತಾಯ್ತು, ಆದ್ರಿಂದ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸ್ರಿ ಅಂದ್ರೆ ಏನದು? ವಾಟ್ ಡು ಯು ಮೀನ್ ಬೈ ಇಟ್? ಶಿ ಇಸ್ ನೈದರ್ ಅಗ್ರೀವ್ಡ್. ಈ ಆಯೋನ್ ಕತೆ ಏನಿದೆ ಅಂದ್ರೆ, ಹಗ್ಗ ಹರಿಬಾರ್ದು, ಕೋಲ್ ಮುರಿಬಾರ್ದು. ನಾನು ಕೇಸ್ ಬುಕ್ ಮಾಡ್ದಂಗ ಆಗಿರ್ಬೇಕು, ಆದ್ರೆ ನಾನ್ ಜವಾಬ್ದಾರಿ ತಗೊಳ್ಬಾರ್ದು. ಅವಳು ಕೊಟ್ಟಿದ್ದಾಳೆ. If he is really interested, he should have obtained complaint from the minor guardian, or he should have obtained a report from the medical officer. ನನ್ನ ಪ್ರಶ್ನೆಗೆ ನೀವು ಉತ್ತರ ಕೊಡ್ತಾ ಇಲ್ಲ. There is an offense, I am not disputing it. That is one aspect. The conduct of the IO, shirking the responsibility. ಸರ್, ಪಾಕ್ಸೋ ಇರ್ಲಿ ಬೇಕಾದಿರ್ಲಿ, ಸಿ ಅವಳಿಗೆ ಏನ್ ಸಂಬಂಧ ಇದೆ ರೀ? ಪೋಕ್ಸೋ ಅವಳಿಗೇನು ಸಂಬಂಧ ಇಲ್ಲ, ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇದ್ದಾಳೆ. ನೀವು ಇಟ್ ಈಸ್ ವೈಲೇಷನ್ ಆಫ್ ದಿ ಕನ್ಸರ್ನ್ ಪ್ರೊವಿಷನ್ ಆಫ್ ಲಾ, ಫೈನ್. ನಿಮ್ ಕೇಸ್ ಏನಾಗ್ಬೇಕಾಗಿತ್ತು? ಡಾಕ್ಟರ್ ಗಳಿಂದ ಒಂದು ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಸುಮೋಟೋ ಕಂಪ್ಲೇಂಟ್ ತಗೋಬೇಕಾಗಿತ್ತು, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಅದನ್ನ ಮಾಡಲ್ಲ. ಹಾಸ್ಪಿಟ್ಲ್ಗೆ ಹೋಗ್ತೀರಿ, ನೀವೇ ಒಂದು ಕಡೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಳ್ತೀರಿ, ಸಹಿ ತಗೊಳ್ತೀರಿ. In whose handwriting this complaint is? ಇಲ್ಲ, ಅದು ಇಲ್ಲ. It admittedly it is not in the handwriting of the victim. 100%. ಅವಳ ಸಿಗ್ನೇಚರ್ ನೋಡಿದ್ರನ್ನ ಗೊತ್ತಾಗುತ್ತೆ. She is incapable of writing except signature. Then who is the author? ಮಾಡೋ ಕೆಲಸ ಮಾಡೋದು ಬಿಟ್ಟು ಎಂತ ಕೆಲಸ ಮಾಡ್ತೀರಾ? ನಿಮಗೆ ರಿಯಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರ, ವಿಕ್ಟಿಮ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದ್ರೆ, ಯು ಶುಡ್ ಹ್ಯಾವ್ obtained a report from the medical officer. ಸುಮೋಟೋ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ. ಅದನ್ನ ಮಾಡಲ್ಲ. ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಜವಾಬ್ದಾರಿ ಬೇಕಾಗಿಲ್ಲ ಪೊಲೀಸರಿಗೆ. See, 164 statement ಹೋಗುದ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. On record itself, what is they disclosing? I'm not raising any issue regarding 100% there is a violation. Child molestation, POCSO ಬರುತ್ತೆ, 376 ಬರುತ್ತೆ, ಎಲ್ಲ ಬರುತ್ತೆ. Okay, fine. ಆದ್ರೆ ಅಗೇನ್ ಅವಳನ್ನ ಈ ಕೇಸ್ ಹಾಕಿದ victimize, you are making the victim itself. You don't want to get blame on yourself for having registered the case. You want to fix the again victim. ನಾಳೆ ಬಂತ ನಿಮ್ಮ ಹುಡುಗಿನ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾಳೆ, ಅದಕ್ಕೆ ನಾವು ತಗೊಳ್ಬೇಕಾಯ್ತು, ಕಾನೂನು ಏನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ನಮ್ಗೆ ಅಂತ ಹೇಳಿ. You want to be very sail in a safe way without taking any responsibility. Very interesting. ಅವನ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕಾಗೈತ್ರಿ? ಮಾಡೋದೆಲ್ಲ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾನ ಅವನು. ಇನ್ನೇನ್ ಮಾಡ್ತಾನ ಅವನು? In fact, all these are matters to be argued before 482. A serious strictures are required to be passed against him. ನನ್ ಮುಂದ್ ಬೇಕಾಗಿಲ್ಲ, ಈ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರಿ, ಅವ್ನ್ ತಗೊಂಡು ನಾನೇನ್ ಮಾಡ್ಲಿ? When investigation is concluded, charge sheet is filed. Why I should summon his presence? ಮಾಡೋದು ನೇರವಾಗಿ ಹೌದು ಅವ್ರು ಮಾಡಿದ ತಪ್ಪದ, ಡಾಕ್ಟರ್ ಕಡೆಯಿಂದ ಒಂದು ರಿಪೋರ್ಟ್ ತಗೊಂಡು 16 ವರ್ಷದ ಒಂದು ಹುಡುಗಿ ಪ್ರೆಗ್ನೆಂಟ್ ಆಗಿದ್ದಾಳೆ, ಗಂಡನ ಹೆಸರು ಹೀಗೆ ಹೇಳ್ತಾಳೆ, ಅವಳು ಮದುವೆ ಚೈಲ್ಡ್ ಇದ್ರಾಗ ಮದುವೆ ಆಗಿದೆ, ಅದಕ್ಕೆ ನಾವು ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾ ಇದ್ದೇನೆ ತಗೊಂಡು ಒಂದು ಸುಮೋಟೋ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಥಿಂಗ್ಸ್ ವುಡ್ ಹ್ಯಾವ್, ಐ ವುಡ್ ಹ್ಯಾವ್ ಅಪ್ರಿಸಿಯೇಟೆಡ್ ಯುವರ್ ಸ್ಟ್ಯಾಂಡ್. ವೆದರ್ ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಬೇಲ್ ಆರ್ ಕ್ರಾಶಿಂಗ್, ದಟ್ ಇಸ್ ಎ ಸೆಕೆಂಡರಿ. ನೀವು ಕೆಟ್ಟ ಆಗ್ಬಾರ್ದು, ಆದ್ರೆ ತೊಂದರೆ ಕೊಡ್ಬೇಕು. ಏನಮ್ಮ ಹೆಸರು ನಿಂದು? ಈ ವೇಲಾಂಗಣಿ ಏನಾಗ್ಬೇಕು ನಿನಗೆ? ಎಲ್ಲಿರ್ತಾಳೆ ಈಗ ಕೇಳು. ಮತ್ ಗಂಡನ ಮನೆಯಿಂದ ಯಾಕೆ ಬಂದಿದ್ದಾಳೆ? ಏನಾಗ್ಬೇಕು ನಿನ್ಗ ಅಳಿಯ ಅಂದ್ರೆ? ಏನ್ ಮಾಡ್ಬೇಕು ಈ ಕೇಸ್ ಈಗ? The petitioner has filed the petition on section 439 of CRPC for enlarging him on bail in station properties crime number 24 of 22, registered for the offense punishable under section 376 IPC and section 4 and 6 of the POCSO. Child Marriage Restraint Act incorporate ಮಾಡಿಲ್ಲ FIR. ನೋಡಿ, ಬಟ್ ಕಾಟಾಚಾರಕ್ಕೆ ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ. heard the learned counsel for petitioner and learned HCGP as well as learned counsel for respondent number 2. The respondent number 2, who is the minor guardian of the victim, he is also present and submit that she has no objection for admitting the petitioner on bail. The brief factual matrix leading to the case are that the victim is the third child of the respondent number 2, and the present petitioner is a relative of the present petitioner is relative, that is the son of the brother of the minor guardian of the complainant victim. It is alleged that he used to visit her house, the house of the complainant regularly, and he used to express that he intend to marry her as he is in love with her. According to the prosecution, in May 2021, on one day, when the victim was alone in the house, the petitioner came there and under the pretext of marrying her, he committed sexual assault against her will. Thereafter, 2 months later, she was found to be pregnant. And then she brought this matter to the notice of the petitioner, and then they, under the apprehension that if the matter is brought to the notice of the family members, they will be targeted, and therefore they went to a temple, and a Muneshwar temple, and got married. Thereafter, they returned to their families and intimated them, but the family members initially were not happy, but accepted them, and thereafter the victim was staying along with the petitioner and her in-laws. Later on 18/1/22, she received, the victim experienced some pain in the abdomen, and when she was admitted to Vani Vilas Hospital, she was admitted in labor ward, and she has given birth to a female child. In this regard, a complaint came to be lodged by the victim herself, and complaint came to be lodged by victim herself as per the case of the prosecution, and the crime came to be registered. On the basis of this complaint, the petitioner was arrested and was remanded to judicial custody. He has approached the learned session judge, and learned session judge has rejected the bail petition. Hence, the petitioner is before the court. Having heard the arguments and perusing the records, prima facie it is evident that victim is aged about 16 years, and her marriage and she had suffered sexual assault from from petitioner, and she was pregnant. Later on, she married with the present petitioner and delivered a female child. The (164) statement of the victim was also recorded before the magistrate. 164 CRPC before the magistrate, wherein she simply asserts that she had married to the present petitioner and she was pregnant, but she denied the sexual assault against her will on her. She does admit that the petitioner is her husband, but denied the other allegations. Next. Even on perusal of the complaint, it is evident that the complaint is lodged by the victim herself. Interestingly, in the entire complaint, the victim all along alleged that she was in love with the present petitioner and they had physical relationship and subsequently they were married and she delivered a female child. No allegations have been made for initiating action against the present petitioner, but why the investigating officer has taken a complaint from the petitioner, the complainant victim is not at all forthcoming. Admittedly, the minor guardian has not lodged any complaint, nor the medical officer has reported anything. On perusal of the signature, it is evident that the complainant is not the complainant bar victim is not the author of the complaint. And complaint is written by one WPC 7268, at whose instance this complaint was drafted is not at all forthcoming. If the investigating officer is really interested in booking a case, he could have registered a suo motu complaint after obtaining the necessary report from the medical officer, but he again victimized the victim herself in this case, which disclosed his intention. Now it is evident that the victim is aged about more than 17 years and she is capable of understanding the things. The investigation is also concluded and charge sheet has been laid down. The victim is residing with the petitioner and it is submitted that at present, after delivery, she is staying with the minor guardian, respond number 2, and minor guardian submits that there is nobody to take care and sought for admitting the petitioner on bail. Considering all these facts and circumstances and the conduct of the investigating agency, in my considered opinion, the petitioner can be admitted on bail subject to certain conditions. Hence, the petition needs to be allowed and accordingly, I proceed to call the following on. Lakshya wants to witness. ಏನ್ ಮಾಡಕ್ ಕೆಲಸ ಇಲ್ಲ ನೋಡ್ರಿ ನಿಮ್ಮ ಆಯೋಗ ಮಾಡುವಂತ ಕೇಸ್ ಮಾಡಲ್ಲ.
Planet is there. He also stated that
It is not a precedent. It's only a persuasive. Yeah, identically, it is not a facts and circumstances will be always different. And the respondent number 2 has not appeared.
She has appeared. She has appeared.
Unrepresented. ಮತ್ತೆ ಅದ್ನೇ ಹೇಳಿದೆ ಅಲ್ಲ ಒಂದು she could have appeared and she could have ಯಾಕಂದ್ರೆ ಉಳಿಕಿದ ಕೇಸ್ ಒಳಗೆ ಅಫಿಡವಿಟ್ ಆಗಿ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ರೆ I would have considered. ನಿಮ್ದು ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ.
They did not engage advocate.
ಅಲ್ಲ ಅಡ್ವೊಕೇಟ್ ನ ಎಂಗೇಜ್ ಮಾಡ್ಲಿಕ್ಕಿಲ್ಲ, that is a different aspect. But if she represents and files an affidavit, things would have been different. Correct, ನಾನು ಅದಕ್ಕೆ ಹೇಳುದು because to be safer side and here he is a close relative. Here close relative, they are relatives. Here you are third person, not a relative. ಮತ್ತೆ ಮತ್ತೆ ಇಲ್ಲಿ 16 ವರ್ಷಕ್ಕಿಂತ ಅದರ ಅಲ್ಲ ಮಗು ಆಗಿದೆ, ನೀವು ಮದುವೆ ಆಗ್ತೀರ ಗ್ಯಾರಂಟಿ ಎಲ್ಲಿದೆ? ಮದುವೆ ಆಗ ಅವಳು ಮದುವೆ ನಿಮ್ನ ಜಾಮೀನು ಮೇಲೆ ಬಿಟ್ರೆ ಅವಳ ಪರಿಸ್ಥಿತಿ ಏನಾಗುತ್ತೆ? ಅವಳು ಧೋಬಿಕ ಕುತ್ತಾನ ಘರ್ಕನ ಘಾಟ್ಕಾಯಿ ಕೊಡ್ತಾಳೆ. I cannot impose. ನಾನು ಮತ್ತೆ ಹೇಳಿದ್ದೀನಿ. Correct. Then get it quashed. ಅಲ್ಲ ಅಲ್ಲ ಹೊರಗೆ ಬರೋದಲ್ಲ, ಅದು ಅದಕ್ಕಿಂತ ಅಲ್ಲ ಹೊರಗೆ ಬರೋದಲ್ಲ, ಅದು ಕ್ವಾಶ್ ಆದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಹೊರಗೆ ಬರ್ತಾನೆ ಅವನು. ಅಲ್ಲ ಮಾಡ್ಬೇಕದು. ಬಟ್ ಒನ್ ಥಿಂಗ್ you can get filed her affidavit. File ಮಾಡಿಸ್ರಿ, affidavit ಹಾಕಿಸ್ರಿ, ನೋಡೋಣ ಜನರಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. Because that at least something should be there, because they are indulging into proceeding for their marriage after they attaining majority. Some assertion should be there, Allah.
He instructed let him come out.
ಅವಳ ಇಂಟ್ರೆಸ್ಟ್ ಬೇರೆ, ನನ್ನ ಮಗಳಿಗೆ ಮುಂದೆ ಏನ್ರ ಆಗ್ಲಿ ಅಂತ ಹೇಳಿ. ಕಮಿಟ್ಮೆಂಟ್ ಯಾರ್ದಿದೆ? ಅವ್ ಒಳಗದಾನ, ಒಳಗ್ ಕೂತ್ ಏನೋ ಕಮಿಟ್ಮೆಂಟ್ ಮಾಡುದಿಲ್ಲ. ಅವಳು ಏನೋ ವಿಶ್ವಾಸದಿಂದ ಹೊರಗ್ ಬರ್ಲಿ, ನನ್ನ ಮಗಳ್ ನೋಡ್ಕೊತಾನ. ಹೊರಗ್ ಬಂದ್ಮ್ಯಾಗ ಅವಳ ಮಗಳಿಗೆ ಟಾಟಾ ಹೇಳಿದಂದ್ರೆ ಅಲ್ಲ ಎಲ್ಲ ನೀವೇ ವಿಚಾರ ಮಾಡ್ತಿರಕ್ಕಿಲ್ರ. ವಾಟ್ ಈಸ್ ರನ್ನಿಂಗ್ ಇನ್ ಹಿಸ್ ಮೈಂಡ್? ಅಲ್ಲ ವಾಟ್ ಈಸ್ ರನ್ನಿಂಗ್? ಯಾವಾಗ ನೋಡಿ ಚೆಕ್ ಇಟ್, ಯಾವಾಗ ಇರ್ತದೆ? ಮಂಗಳವಾರ ಇಲ್ಲ ಬುಧವಾರ ಇಟ್ ಕನ್ಸಿಡಿ ಆನ್ ವೆನ್ಸಿಡಿ. ಕೊಡಿ. The petition is filed under section 439 of CRPC. All along there is no representation on behalf of the petitioner. in spite of granting sufficient opportunities, the office objections were not complied with. Hence, it appears that the petitioner is not interested in prosecuting the matter. Hence, petition stands dismissed for non-compliance of office objections. You are A2. 14 lakhs cash recovered at your instance from your custody. For along with 1 kg 406 grams of gold. As per the record, and that gold should be available before the IO or before the court. That is mandatory. When they are saying that it is recovered, when PF is submitted, that property is available. At the instance of accused number 1, 8,48,000 is recovered along with 249 grams of gold. and 3 kg 750 grams of silver biscuits. Whatever, it may be, something is recovered, and you are moving from the house, by jumping a compound wall is also recorded in CCTV. Not only accused number 2, accused number 1 and 2 together. He was waiting, initially when there was a conference call, he was in the airport. The present petitioner has sent a location. He came waiting outside. When the accused number 1 finishes everything, he gets entry. Whether you are met or not, that is a different type. You had a conference call. See, A1 caused the death. He has throttled his neck. Throttling of neck is there. Then you all along in the morning you are arguing that it was because of some respiratory, because of he was. It is there. Okay, that is one aspect. But the serious allegation is that A1 has throttled his neck. Sir, his intention is to tie and place him in bathroom. He tied it. When he tried to resist, he put some stuff in the mouth and throttled his neck. A aged person, 73 years, and he has given a bread to you. You are a partner. You never met, then how did you have a conference call with him? An unknown person, can you have a conference call? Yes. Then if that is the case, okay, let us accept it. Even let us accept that there was no conference call. At the instance of A1, how a recovery can be done at your instance? That too, 14 lakhs cash. It is not a small amount. And when you are committing a theft, in which house committed, how it was committed. And in the process to rob the person, aged about 30, he has given a bread to you. You targeted him. What else is required, sir, at this juncture? What is the special grounds to grant a bail to you? Where you stay is a secondary thing, sir.
He was not an expert. He had no not.
Then how did you secure the properties of the deceased? The specific CCTV footage also disclosed that A5 has dropped A1 near the location. Why not in location? Near to area is different. Location means Exactly. A5 has dropped A2. A5 has dropped A2.
Yes.
And he entered the house. Along with him, they cleared everything.
By then he was standing. He was standing in the violent, he commits and he comes out, he jumps the ball, then he gives the back to the then they in the apartment building there.
Then why did you, if you are unknown to him, why did you fled with him? That is, you are the best person to explain.
One of the son of the deceased, he says that he used to go on the way. That was not he and say that this is for yes, for either company also for I don't
If everything, even then, the question is, your recovery is not a small thing. 14 lakhs hard cash plus almost 1 kg, 400 grams of gold. Then sir, committing theft is one aspect. Had it been only a theft, things would have been different. In the process, you caused the death, and it is not only a theft now.
Yes, I understand, but it was only known to the petition number one, because he says that when he was resisting.
No, sir, looking to the serious allegations.
He was
Looking to your involvement, recovery of such a huge amount belonging to deceased, this is not a ground for you to grant a bail, sir, at this juncture. Reconsider. After arguing the matter for some time, the learned counsel for petitioner suggests that he may be permitted to withdraw the petition with a liberty to take appropriate steps at appropriate time. The submission is placed on the court. Remember it, Kevin?